nakon svečanog otvaranja oko finansiranja političkih partija i izbornog kampanja i generalno oko političke korupcije kao nešto što sistemski nagriza crnogorsko društvo. Danas ćemo fokus staviti na oduzimanje imovine stečene kriminalnom djelatnošću i oduzimanje imovine za koje nije poznato nije poznato porijeklo. I očekuju nas dva veoma zanimljiva panela. Jedan će biti oko međunarodnog iskustva i tu imamo jako zanimljive sagovornike. Imamo vrhovnu državnu tužiteljku Slovenije, imamo predstavnike italijanske Guardia Finanza i nakon toga imamo radni panel gdje ćemo sa predstavnicima domaćih institucija, policije, tužilaštva, Ministarstva unutrašnjih poslova, Agencije za sprečavanje korupcije vidjeti kako zapravo izgleda stanje stvari, šta je potrebno izmijeniti, ali prije svega toga imam veliko zadovoljstvo da predstavim, odnosno nije potrebno, znači, dodatno predstavljati gospodina Vladimira Novovića i gospodina Bojana Božovića, Ministarstva pravde, koji će dati uvodna izlaganja na današnjem panelu i evo sad bih dao riječ gospodinu Novoviću i moram da podcrtam da nam je veliko zadovoljstvo ne samo za to što je danas ovdje, što je pristao da priča na našoj konferenciji, već prije svega što njegovi rezultati, evo, makar nama iz MANS-a koji već 20 godina punimo tužilaštvo dokazima za korupciju i organizovani kriminal, daje nadu da neke stvari ipak mogu da se promijene. Izvolite.
Hvala vam na datoj riječi i na vašem pozivu kojem će se uvijek rado odazvati. Poštovane dame i gospodo, cijenjeni učesnici konferencije, čini mi veliku čast i zadovoljstvo da danas otvorim drugi dan 17. nacionalne antikorupcijske konferencije. Dozvolite mi prije svega da uputim izraze iskrene zahvalnosti organizatorima, nevladinoj organizaciji MANS na ovoj prilici, ali i na njihovim kontinuiranom radu i doprinosu u borbi protiv korupcije u Crnoj Gori. Rad MANS-a na polju afirmacije transparentnosti, odgovornosti i borbe protiv korupcije predstavlja važan segment u kreiranju šireg društvenog konsenzusa protiv ove pošasti. Korupcija nagriza temelje našeg društva, urušava povjerenje građana u institucije i koči sveobuhvatan
progress of our country. This is why the fight against corruption is not only a legal but moral imperative for us, of utmost importance for the welfare of Montenegro. I would especially like to single out that today's topic, confiscation of the proceeds of crime and assets without proof of origin, is central when it comes to the modern criminal law in our endeavors to fight criminal structures, financial investigations, and activities of seizure of proceeds of crime are as important as the criminal procedure itself. Justice cannot be full if we do not ensure that the proceeds of crime are not confiscated from those who obtain it illegally. It is indeed through the confiscation of the proceeds of crime is the hard hit on the criminal structures from which they cannot recover, and it has a significant preventive effect. The Special State Prosecutor's Office recognized the importance of this institute and is committed to improving the results in this area as well. Even though we face with limited human and technical capabilities and resources and certain challenges when it comes to legislative framework, we managed to obtain significant results. The discovery and confiscation of the proceeds of crime in the upcoming period remains one of the critical priorities of the Special State Prosecutor's Office. This goal and tangible results as well can be obtained only in cooperation with other state authorities, with preventive and repressive measures, and with the support and partnership of the NGO sector and international partners as well. I would like to thank for your attention, and I wish you a fruitful work today and productive discussions during today's panels. May the discussion contribute to further affirmation of joint values and goals that bound us all in fighting corruption to reach a more just society. At the end, I would like to emphasize that the decision makers, in terms of the political decision makers, need to consider the French model as well in this regard when it comes to seizure and confiscation of the assets, and to establish a special institution that should be in charge of that asset. Having in mind that currently, under the jurisdiction of the administration for state property, which represents a very big administration. And I believe that in this sense, the specialization by following the French model and French institutions would be of utmost importance for our society. And in that sense, we need to think and consider establishing such an institution. Thank you very much once again for your attention. Thank you very much, Mr. Novović, for your kind words. And now I would like to invite Mr. Božović, the Minister of Justice, to take the floor and to tell us whether there is a goodwill within the executive branch to follow the pace that was mentioned by Mr. Novović and create the conditions and environment to fight corruption in institutions, and also with the focus of confiscation of the proceeds of crime to make it a more efficient process. Here, Mr. Novović, here, Mr. Milovac, colleagues and friends. It is a great pleasure for me to attend the conference today and to have the opportunity not only to discuss, but I believe also to hear various suggestions, recommendations, and perhaps critical approaches, which will give us a clearer picture of possible missed opportunities that we have faced in the previous period and that we need to decrease in the upcoming period. Distinguished Special Prosecutor mentioned that it is a pleasure for him to attend this conference today because this event is organized by MANS, the NGO, and I need to refer to something that you mentioned, that you have been dealing with this topic for 20 years within MANS. Now you can understand how important it is for me, since I come from an institution that does not have, that is understaffed, that have been working for such a long period. This means that your experience, your knowledge, your recommendations are something that our state institutions need to benefit from, so as to jointly, in partnership, create a legislative framework, but also, what's even more important, to enforce and implement everything that is necessary. I would like to use this opportunity also to reiterate that the law on confiscation of the crime in various iterations has been announced to be amended, and with these amendments that the set goals would be reached, which is a desirable scenario for all of us here in attendance and in the country, to fight a decade-long injustice and to take remedial action. However, we still haven't succeeded in this. The amendments that were adopted through IPAR were only one part of recommendations that were adopted. However, significant segment is still ahead of us. And this is why the Ministry of Justice established a working team, a working group that will focus on the amendments of all these pieces of legislation. I would furthermore like to emphasize that we will organize various panels and discussion sessions so as to analyze various options available and suggestions so as to reach a joint best hopefully solution at that moment. Recently, we had a roundtable discussion organized in cooperation with the Agency for Corruption Prevention regarding the law on corruption prevention. We made various suggestions during these discussions, and we wish to apply the same regarding this law. It doesn't mean that we need to organize exclusively formal conferences and meetings to use that model and approach, but we need to consult with those who have greater knowledge than we do in this area. First and foremost, because we need to be honest and open, really questionable if we have sufficient practical experience and knowledge in this field. This is why we need suggestions by the Special State Prosecutor's Office, courts, as well as the civil sector and other institutions. I would also like to emphasize that this is not only the matter that is with reference to the amendments of the mentioned law. If we wish to close the negotiating chapter 23 before the end of 2026, which is envisaged with the roadmap that we have aligned with the European Commission, the second measure has to do with the confiscation of the proceeds of crime and implementing these measures in practice, in practical terms. So this is these are the obligations stemming from the mentioned negotiation process that we need to meet. So it's not only our obligation to implement all of this because of us here in Montenegro, because of the national interests. This is something we need to do also because of the negotiation process. Furthermore, I would like to emphasize that, and I would like to encourage once again everyone and reiterate that I will endeavor with personal example to keep the door of the Ministry of Justice open for all stakeholders and everyone. I had the opportunity to hear experiences based on the French model provided by the Chief Special Prosecutor. We will consider that model that we already have certain positive experiences through some other models, such as the Italian model. It's very important to adapt all of this and to show commitment and goodwill to face the challenge that we mentioned. I would like also to emphasize, and this is something that was also mentioned yesterday by the President of the government, Prime Minister, we need to target the proceeds of crime through the tax administration as well as other relevant institutions that will for sure be in a position to fill in certain of the gaps when it comes to the acquisition of assets, to be euphemistic, and to qualify it as a clear signal in which direction the competent institutions need to go and need to take. Once again, it is a great pleasure to be with you here today, and I'm sure that we will have the opportunity to go into details regarding various options. Thank you very much for your attention.
Thank you. Let me start with from where Minister Božović said, the comprehensive revision of the legislative framework, anti-corruption legislative framework and confiscation of proceeds of crime legislation is something that we need for the sake of our citizens. The perception, with all due respect, that this is only done for the sake of European integrations, to tick the box on the path to European integrations should not replace the fact that we have to do it for our citizens without intention to sound populistic. I think that we need them and all these laws for the sake of our citizens rather than for the sake of only IBAR. We believe that by the end of the year, we hope to have the new amendments in place, the new draft in place. However, we will have to pick it up from there and start also in the new year, in the coming year. Unfortunately, what happened from June on, nothing happened. We saw that the anti-corruption law acted in a very damaging way for all those proceedings that started and that were tried and prosecuted on the basis of the previous law. I want to say that the knowledge that civil sector MANS commands is not something that we keep to ourselves. This is what we put to your disposal, and this is where and only those who had political will for that could benefit from it. And we haven't got the justice served. I don't think there is someone in the room who can say that in case of Svetozar Marović, most notorious case of high official trial and conviction, we see that the law was satisfied, but the justice not. The law was served, but justice not, and no one mentions 3.8 million US dollars that were kept at the account of his wife of Mr. Marović. It is hard to believe that this was the only money they had. They have transformed that money into something else, but from the aspect of our state and our institutions, it has been lost. As of next year, we will have a new working group then, and while we are sitting here, dirty money is getting new layers of offshore companies, the new property. The witnesses are silenced, the evidence destroyed, and so on and so forth. So while we are waiting for anti-corruption law, anti-corruption act, we will come into position where we can't offer anything to our citizens, and 200 billion euros were lost in the cigarette smuggling case and cigarette smuggling activities is enormous and unparalleled compared to other countries. We as society shouldn't, we don't do much to weaken and to bring down their economic power, their financial power, and we need to make sure that we don't create again the context that we had before 2020. If we let the organized crime be present, be around, and if we adopt the laws that serve everything but the public interest, when we look back in the last couple of years, what we see is that we have now better results in a fight against organized crime and corruption at high levels, but there is always a but. And this is rather concerning given that the Special Prosecutor's Office and prosecutor himself invest enormous efforts, but you see that you don't see much of an epilogue in the court. We saw what happens with high-profile case, just like former president of Supreme Court, Medenica and others. We see that all the efforts invested by the Special Prosecutor's Office may be squandered. And we might see that some repeat in some cases like Šarić, Kalić, and others may be repeated. And we have to make sure that we have to reform the prosecutor's office, and it will all be useless unless we have a strong support from executive branch, and when it also from legislative power as well. And let me mention another thing, and that is vetting. After 2020, almost every Minister of Justice, including the present one, mentioned vetting, promised vetting. After the case of former President of Supreme Court, which is a good motive to do the vetting in judiciary, where we have a case where the top echelons of the Supreme Court were involved, and there is a reasonable argument that it has been spread. It was spread throughout the system. We can only speculate now how far have those criminal organizations infiltrated into the system. If there is no alternative to acting against it. We saw and heard lots of arguments about paralysis of the system. Can you imagine more paralyzed system than that? just imagined some 20 delayed hearings in case of Medenica. Just take a look at other cases that are tried before our courts, and we need to revisit the idea of having a special court where judges would be only doing the top-notch and biggest cases of organized crime and corruption. And this will be the biggest challenge in closing this chapter, unless we let the prosecutor's office and the judiciary, we can't do much. We need some final judgment and confiscation of criminal proceeds. Could you please not leave the room? We will just make and change the panel. We will hear experiences of Slovenia, Germany, France, and Italy, Serbia as well. We will hear about their experience on confiscation of criminal proceeds. Good luck.
Good day once again, and welcome to the second day of the National Anti-Corruption Conference. As you were able to hear during the introductory session, we will be discussing two key pieces of legislation in this area: the law on the confiscation of the proceeds of crime, and also the law on the confiscation and property without the proof of origin for the assets that we do not know the official origin and cannot be justified with official incomes of the persons concerned. This activity, as it has been the practice in previous year, these pieces of legislation were something that we waited for a long time, and finally they were given overnight, so to say, because of obtaining the well-known IPAR package. During the first panel, we will discuss the international experience in this area, and my interlocutors are persons with rich experience. Then they can contribute to illuminating various aspects of this area, and also to learn something and apply as well. It is a great pleasure to hand over the floor and welcome Ms. Barbara Lipovšek, Supreme State Prosecutor of Slovenia. Ms. Lipovšek, the floor is yours. Good day. Good day, everyone. Good day, everyone, once again. This is the third time that I say good day. Their attendance, a warm welcome, and congratulations to MANS for a wonderful organization of the conference. And I thank for the invitation given. As Ms. Diana mentioned, I come from the Prosecutor's Office. I'm currently Supreme State Prosecutor of Slovenia. However, as of 2012 until 2014, I served as a member of the Special State Prosecutor's Office in Ljubljana. And I was in charge for 10 years of the department that, among other things, focuses on the confiscation of the proceeds of crime. My added value at this conference, I see in sharing some good and bad experiences with you from practical work. As I was a member of a team that firsthand had this wonderful and important experience, and as both individuals and organizations, we learned a lot from our experience. Perhaps the experiences that I will share with you will assist you to get a new idea or find a shortcut in order to establish a system that would meet your own needs and would be in accordance with your legal system itself. In a nutshell, let me refer to the legal framework. In Slovenia, in the jurisdiction of Slovenia until 2012, there was only the criminal law provision regarding the confiscation of the proceeds of crime, the so-called classical confiscation, molded and by the system of confiscation of the proceeds of crime in combination with the confiscation of assets that correspond to the proceeds of crime, or rather paying the amount that is equivalent to the proceeds. As of 2009, 10, and 11, the politicians in Slovenia reached the conclusion that the population in Slovenia, to a large extent, has proceeds, is in the possession of the proceeds of crime. And at that time, we discussed whether to introduce certain provisions of extended confiscation under the criminal code, or to introduce civil confiscation of assets, confiscation in rem, by following the Irish model and experience. Our legislature decided to solve this issue in two ways. The first one is the following: taxation of the assets for which the owner cannot explain the origin. This is by the threshold of 70%, and with the adoption of law on confiscation of the proceeds of crime. This law is called, she mentions the Slovene version of this law. We call it ZOPNI. This is an acronym. So we will use this acronym ZOPNI to refer to this law, the piece of legislation in Slovenia that she mentioned. By the adoption of ZOPNI, we enable the confiscation of the proceeds of crime from persons from which there is suspicion that they have committed a certain criminal offense. Here we are talking about the institute of civil confiscation that is characterized by the fact that is not based on the criminal judgment, because the repression of the country is not focused on the person, but on the proceeds, which means in rem. ZOPNI is based on the presuppositions that no one can obtain any advantage and benefit from the proceeds of crime, and the financial means are the key motive for potential criminal offenses and the goal of the criminal offenses themselves. This means that if I want to explain this matter in a concise manner, we have three instruments in Slovenia for the confiscation of the proceeds of crime. The first instrument is the so-called classical criminal confiscation, regulated under Article 74 of the Criminal Code of Slovenia. Then the confiscation of the proceeds of crime according to ZOPNI law, and taxation undeclared income according to the Article 68A law on the tax administration procedure. Now, the classical criminal confiscation is a traditional and undisputable instrument, relatively speaking, the efficiency of which is limited by the request for the final judgment, criminal judgment, and based on the proof between the proceeds and the criminal offense committed. Now, the taxation of undeclared revenues in the current form has been introduced in 2014, but the roots go back to 1997. Even though the taxation of undeclared revenues is an institute under the tax law and focused on the prevention of the evasion of taxes, the assets from the illegal activities include the proceeds of crime, which are focused on the confiscation with non-convention-based confiscation of assets. Now, when I talk about the schedule and the steps to be taken, this is not regulated organically when talking about our legal system. And in practice, the three proceedings can run in parallel, even though this is not very often the case. In most cases, we have a cascade approach to confiscate through first the criminal procedure, then ZOPNI, and then the tax. But this is why we need to be careful constantly not to have double confiscation. The law itself, though, so the ZOPNI that I've mentioned, under Article 57, envisages the confiscation of the proceeds of crime committed before entry into force of the law from January the 1st, 1990 and onward. And the Constitutional Court back in 2018 ruled to be unconstitutional provision because it breaches the principle of legal certainty and as well as the right to property, which is protected under the Constitution. By enabling to repeal the Article 57 of the law, the retroactive effects have been cancelled, and the scope of investigation is limited on the time frame from the adoption of ZOPNI, which is November the 29th, 2011 onwards. And this judgment by the Constitutional Court unfortunately occurred only in 2018, meaning that this occurred only 6 years after the commencement of the application and enforcement of this piece of legislation. And I need to point out that during some public open discussions before the adoption of this law warned against this in a timely manner. Why I am mentioning this? Because the decision made or delivered by the Constitutional Court had a drastic consequence and repercussions on certain cases, according to the ZOPNI law. In the large case of open cases back then, we had the situation that the criminal offense was committed before November the 29th, 2011, or the proceeds were acquired before that date. Consequently, without the confiscation of the proceeds of crime and the substantial assessment, all the major and most important disputes regarding the value of the proceeds of crime were terminated in such a manner. Apart from that, we need to know the following. The decision of the Constitutional Court will have and still has the slowing down effect. And this will be the case for the years to come and for the future cases based on the ZOPNI under which the criminal offense was committed before 2017. Now, why am I mentioning this year specifically? Because in these cases, it wasn't possible to investigate the overall 5-year-old period prior to the commission of the criminal offense. Another important judgment of the Constitutional Court needs to be mentioned. In 2020, it quashed the segment of the tax law that envisaged the 70% tax on the established undeclared property and assets of the natural persons. And this is based on the assessment that this provision is not aligned with the Constitution, first and foremost, the principle of equality before the law and legality of the tax system itself. Even though our law on the confiscation of the proceeds of crime entered into force in 2012, the first novelty was received in 2014, and the new novelty amendment is underway. And everything that I have mentioned so far, I would give a well-intentioned recommendation regarding these matters, that it is necessary to prepare a quality and good piece of legislation, because only this can serve as the grounds for an efficient legal system and provide clear, just, and applicable rules and provisions that enable a just approach towards all the citizens. Now, the next point I will refer now to has to do with financial investigations. So financial investigations are currently, as we all know, the strongest tool, the most powerful tool that we have at the moment. In my country, we have two types of financial investigations. The first is the so-called integrated financial investigation, which is implemented or enforced by the police according to the law on criminal procedure, or criminal procedure code, rather. And this is a process encompasses conduct simultaneously financial and criminal investigation, which enables an overall and comprehensive analysis of the criminal acts and offenses, especially those involving economic crime, corruption, or organized crime. Who are the entities? Everyone, natural, legal persons, the persons to which the benefits have been transferred, and so on. And they use the approach follow the money. And the verification of the assets is performed as the cabinet verification, the so-called cabinet verification, or the so-called field verification, during which the lifestyle is being verified of the persons concerned. I know that they cooperate a lot with various other institutions and authorities in these activities in the country, both in the country and abroad. So Europol, Cutting Network, and other. The Tax Administration, the Commission for the Prevention of Corruption, and other authorities. Regarding the financial investigations, according to the Zopting law, this is with reference to the other type of financial investigation. According to the current law, they are obligatory and based on the fact that between the members of the investigation teams, there is a strong cooperation. And I need to emphasize that this cooperation in our case is really good and efficient. The members, they work as the permanent investigation teams, so we have capacity, and I need to emphasize that our experience in terms of the cooperation with them is wonderful, and the idea of our prosecutor's office that maybe still hasn't been realized and implemented, but I'm hopeful that it will be the case one day. These investigative teams should become permanent teams, standing teams, because right now for each example and case when the investigation is performed, each institution, so both the police administration, other institutions such as the prosecution, and so on, they delegate an individual that is in charge of the matter and the case. However, the financial investigations, according to the Zopting law, are not numerous, so as to require the constant engagement of these persons in investigative matters, but they are engaged ad hoc rather. My personal opinion is if we establish standing investigative teams, the experts would really become specialists for the field, and it is something that is required for an efficient work to be performed. Since I have already mentioned that right now we are collecting ideas for the upcoming amendment to the law, I think I can say it that the suggestion by the prosecutor's office was along the lines of taking into consideration the investigative team that is at the beginning of investigation established, and it is the dissolution occurs after the finalization of the investigation. So this team should be operational until the end of the proceedings, because the prosecutor in charge of the proceedings constantly needs information from other institutions, and this team needs to be operational, and it would be a good idea for them to have a longer, to be operational for a longer time period. The second recommendation in this regard would be the following. It's constantly important to work in terms of a good cooperation with institutions regarding the financial investigations, because each individual doesn't have sufficient power if working in silos. We need to establish a chain of knowledge. And information exchange from various institutions, and this is the road to be taken to have efficient investigations. I would like to share also the following point, and this is based on our experience, and this will be the case with your experience as well. Back in 2012, when we started working on a case, I believe that my institution and all the other stakeholders and other institutions which I need to compliment for their work have used a lot of resources, knowledge, and time, and of course, goodwill, sincere goodwill, when it comes to the education of all the individuals who are involved in these activities. And in such a manner, all the institutions simultaneously were growing, developing, and based on our experiences, we were able to use that in practice in an efficient manner. So this would be recommendation number 2 from my side. And since I'm not alone at the panel, I'm reaching the end of my presentation, I would like to mention one more thing. It's something that I heard yesterday, actually, and with which I agree. People around the world act based on our internal values, convictions, and motives developed within the environment we live in. And the legislation can provide a framework and direction and guidelines. However, the basic impulse that impact the acts of individuals stem from their internal nature and life experiences that is formed in a certain societal environment. So this means that all of us need to work constantly on establishing the culture of legality. Thank you very much for your attention.
So in percentages, we don't know what the question was. I can't tell the percentages. I can have the data with me, the information with me. For some more information, I need to contact our institutions back in Slovenia, and if they approve of it, we can send it to you. We have the public prosecutor in State Prosecutor's Office in Düsseldorf, Mr. ChristianHaßelmann. Mr. Haßelmann, welcome here. Thank you for taking time to come here, and you have
Ich hoffe, ich bin jetzt zu hören. Gut. Ja, vielen Dank für die Begrüßung. Vielen Dank für die Einladung und die Möglichkeit, bei Ihnen sprechen zu können. Vielen Dank auch für die Einladung und die freundliche Begleitung durch das IRZ. Wie Sie eben jetzt schon erfahren haben, bin ich beschäftigt bei der Staatsanwaltschaft in Düsseldorf und dort im Speziellen in der Schwerpunktstaatsanwaltschaft für Wirtschaftsstrafsachen. Bei der Staatsanwaltschaft Düsseldorf gibt es außerdem auch noch eine Zentralstelle zur Verfolgung von organisierter Kriminalität, sodass wir beide Abteilungen eng verbunden sind und uns gegenseitig ergänzen. Folglich bin ich auch nicht nur für die wirtschaftsstrafrechtlichen Dinge mit eingebunden, sondern auch bei der Bearbeitung von Einziehungsfragen, die die organisierte Kriminalität betreffen. Einleitend zur Vorstellung unserer deutschen Regelungen zur strafrechtlichen Vermögensabschöpfung will ich darstellen, dass die deutschen Regelungen im Jahr 2017 eine grundsätzliche Änderung erfahren haben. Grund dafür war insbesondere die Vorgaben einer Richtlinie der Europäischen Union, die eben dem deutschen Gesetzgeber aufgab, die Regelungen zur Einziehung im strafrechtlichen Bereich zu überarbeiten. Außerdem hatte aber der Gesetzgeber 2017 erkannt, dass die bis 2017 geltenden Regelungen zur strafrechtlichen Einziehung sich als unbrauchbar erwiesen hatten. Ja, sie wurden in der Praxis, in der Justiz als zu kompliziert und unzweckmäßig empfunden und stießen daher auf wenig Akzeptanz. Bis 2017 galt es auch im Grundsatz eine Trennung zwischen Verfolgung von Straftaten und der Verfolgung von Einziehung zur Opferentschädigung, sodass bis dahin gedacht wurde, die Opfer und die Geschädigten von Straftaten müssen zivilrechtlich ihre Ansprüche gegen den Täter verfolgen, und das Strafrecht ist nur dazu da, grundsätzlich eben die Strafen zu verfolgen. Das hat sich allerdings seit 2017 und die Änderungen der Gesetzeslage doch erheblich verändert. So die Regelungen, die in Deutschland nun ab 2017 zur Wirkung gelangen, haben insbesondere bewirkt, dass mittlerweile bei der Einziehung, das Thema Einziehung, insbesondere bei der Bekämpfung von organisierter Kriminalität und Wirtschaftsstrafsachen, eine hohe Aufmerksamkeit erfahren hat und mittlerweile als zentraler Baustein zur Bekämpfung von organisierter Kriminalität und Wirtschaftsstraftaten geworden ist. Die deutschen Regelungen zur Einziehung sind grundsätzlich vollständig in das Strafrecht mit eingebunden. Unsere zentrale Regelung, der Paragraph 73 Strafgesetzbuch, besagt, dass das, was der Täter durch oder für die Tat erlangt hat, grundsätzlich der Einziehung unterliegt. Man erkennt daran, dass der deutsche Gesetzgeber keine Vermögensstrafe verhängen will, sondern die Regelungen grundsätzlich darauf abzielen, den Zustand wiederherzustellen, der vor der Straftat herrschte.
That is why we wanted to make sure that our legislation says that the confiscation is mandatory. So the prosecutor court cannot but confiscate proceeds of crime. If someone is convicted for a criminal offense, or if that person has acquired property, the consequence of the court trial should be that it ends up with confiscation as well. If proceeds of crime is non-existent, then we can take something out of from his legal assets. So since he spent illegally acquired assets, and if we can't find that property, then we are allowed, the legislator allowed us to confiscate also from legal assets in the amount proportionate to the value of illegal proceeds. And so we are to estimate the value, and we take that value from the legitimately acquired property. It is taken from the overall assets of the criminal offender. It could be real estate, money from account, everything. Another principle from the German legislation is in Article 75 of the Criminal Code, which stipulates that the assets, if the victim or a damaged party is not identified, that the proceeds that are confiscated are to be owned by the state. The consequence is that we first indemnify the injured party, from the criminal proceedings. So they are not obliged to start a legal action to satisfy their claims and to be indemnified. If there is no one injured party or injured party does not want to be compensated, anyway, the offender won't keep it, but criminal proceeds become the property of the state. Apart from that, in 2017, the legislator prescribed the rules as to how to act if a perpetrator has not, or offender has not acquired the property himself, but if he did it in or within a company, on our enterprise, we can also take the proceeds from the assets of that company or enterprise. Legislator also gave us possibility to take the assets from the third parties to whom the offender has transferred ownership of the property or gave the property away to them. It is something that is very important for us, especially when we work on cases of organized crime where the criminals usually make sure to transfer property to some third party. With the help of this article, with the help of this legislation, we can also confiscate from third parties. The legislator gave us possibility to make a standalone confiscation out of some reasons. For example, the investigation cannot be continued against person and due to the statutory limitations or expiry or of the validity of certain rule, then we can do a standalone confiscation where we could, independently from the proceeds, to actually take and confiscate the assets acquired irrelevant to the or without prejudice to the proceedings. Then the property of ambiguous origin or unknown origin. So this is about extended this is related to extended confiscation method. Let me explain. If you investigate a corrupted official who, for example, got 10,000 euros for something he did, in your investigation, you find that official didn't take just 10,000 euros in cash or to his account, but he also got some 50,000 euros that he got to his account, and he can't explain how he got it. The law gives us possibility to confiscate that money as well. Of course, there are some assumptions that we need to meet here. That criminal offense that we initially prosecuted has to be finally tried and end up in a final judgment. And that the criminal offense from which he obviously got the money do not need to be specified. The criminal offenses they cannot do not need necessarily to be specified, but that we could make good assumption that that comes from some other suspicious activities of that person, and having reasonable doubt that that he acquired such in some criminally incriminated way. As for the court, we'll speak about that later on. The legislator gave us another possibility to confiscate the property of ambiguous origin. That is the most interesting innovation that we got in 2017. The legislator in Germany for the first time tried to insert in our system the confiscation of property without criminal offense. It is different from extended confiscation. And it is from Article 46. It is standalone confiscation without final judgment and final conviction. You have prosecuted, you stop the proceedings, criminal proceedings, because you didn't manage to prove, but you can still confiscate property that you have seized during the trial, and that you take it on the grounds that he can't explain where he got it. So this is the fact that despite the proof of proving the existence of criminal offense, you have to establish that through investigation, and it has to be listed in the catalog of criminal offenses. The catalog of criminal offenses from Article 76 are criminal offenses of the organized crime. In the catalog, you have for example, establishing criminal organization, money laundering, etc., etc. So you have to conduct the criminal proceedings against the defendant, and eventually confiscate. If you can't prove money laundering case, you have to, you can confiscate seized property. For example, if there was a theft, you don't have that possibility, that option. I looked at the catalog. Corruption cases are not listed in the catalog. I checked it just for the sake of this conference. And as for standalone confiscation, I have to say that, you have to assure the court that the property comes from some criminal offense, even though at the moment you cannot establish for sure. As for the legislator, he gave us the legislation gave us the guidelines as to how judge should do or go about that to establish whether an asset or property has been acquired through crime. These are directions, guidelines, and instructions. However, it doesn't lead to reverse burden of proof. I, as the prosecutor, have still to prove that defendant acquired illegally the property, the assets that are confiscated. It sounds pretty easy, however, it's very difficult in practice, because the defendant might say that something relatively logical, and we can't directly claim as a lie. Then we have to, we as prosecutors have to conduct financial investigations, and that is what we have specialized department of the police for. There is a special police team that works with us. They have lots of experience, knowledge, and competence to help us do the criminal and financial investigations in parallel. So those novelties, those amendments from 2017 have been accepted very positively, enthusiastically in Germany, and it helped us conduct investigations in commercial, financial crimes, and organized crime cases, and We tend to confiscate property from organized crime so that perpetrators, offenders of crime get a chill off, and that we prove them that the crime doesn't pay off. There are also critics to standalone confiscation when you can't prove the existence of offense, criminal offense and crime. But as I've said, you have to do that only in criminal cases. And the defendant, for example, can, of course, refuse to speak to his damage, to give statements that would be damaging to them, whereas we have to prove that the assets that we are to, and the proceeds are that we are to confiscate are proceeds of crime. As for stepping up and intensifying the implementation of the law, we are discussing some ideas in Germany to make this confiscation fully separate from criminal proceedings and prosecution, that we should have a special institute for confiscation, instrument of confiscation, so that we don't have to run and conduct the criminal or financial proceedings, so that we can do it all along the proceedings. And now we would not have position that the defendant who doesn't speak to his damage, he doesn't want to take the damaging statement, and then to share the burden, to reverse the burden, to request that he proves the legality of the origin of proceeds. So, but this is still a matter of discussions in Germany, so that confiscation of proceeds of crime is running in parallel with criminal prosecution. Thank you for your attention, and I'm here for your questions. So, third time lucky. NicolasMichon is with us. He is judge in the cassation court in France. We have him on the Zoom link. Mr. Michon, we heard today that French model is one of the models that should be considered and used in Montenegro. Sorry, what does it look like?
Yes. Good morning, everyone. I will be giving this presentation in English, which is my other professional language. So the French law of criminal asset seizure and confiscation is now a major item in the struggle against corruption and organized crime. You should have on the screen a brief history of, let me see if, a brief history of it. First, asset confiscation, it's called forfeiture in common law system. It's a penalty that's imposed after a criminal trial, and asset seizure is a preliminary step taken during the investigation and meant to prevent the disposal of the assets before they can be confiscated. Now, to understand where we are now, it is useful to go for a brief history of our law regarding asset confiscation and seizures. Contrary to what you've seen in the German code, which has its own dedicated provisions, our law grew out of a single article, Article 131-21 of the Code Pénal, which was enacted in 1994 and largely consolidated much older provisions. So at that time, when somebody spoke about confiscation, it was meant to be the confiscation of weapons, drugs, maybe cash found at the scene of the crime. And it didn't work very well, in part because of the way our system worked. These were supposed to be part of the case file, exhibits, so to speak. And we had tons of problems with storage. So drugs, money, sometimes weapons, could disappear from storage. Asset confiscation was theoretically possible in some cases, but it was almost never used. There were three major reforms that really started changing things. One was in March 2007, which extended the cases in which confiscation could be imposed. One was in July 2010. In some ways, it was the most important because it created a dedicated agency to manage the assets that were confiscated. And the last really important one was in March 2012, because that extended confiscation to assets that are not only legally owned, but are at the libre disposition in France, which I translate by free disposal. The concept is that these are assets that the defendant has effective control over. There's a generic provision in Article 131-21, which is that the confiscation applies if the offense is punishable by more than 1 year of imprisonment, or if it is specifically set forth in the applicable statute or regulation. There are some minor offenses, quasi-administrative offenses, for which things can be confiscated. This is, for instance, the case for, environmental regulations or consumer protection regulations. So if you're selling, trinkets that run afoul of safety regulations, they can be confiscated. It is no exaggeration to say that nowadays, this is where most of the action is. If you talk to criminal defense attorneys, or if you overhear them speaking in bars or cafes around the courthouses here, they will tell you that this is what their clients really care about. Jail, most of them sort of deal with it, but having the villa with the swimming pool in the home country confiscated, they just can't have that. So what we will do now is go through the headings under which assets can be confiscated. So the first one, and that's the oldest one, is the assets that were used to commit the crime or were meant to commit it. So since 2022, it extends to assets that the convicted person had the free disposition of. This one was one of the last ones to get that little change. And the exception is the rights of the good faith owner of rights on the asset. I will cover this here, but this reservation of the rights of the good faith owner is a theme that runs across our law of confiscation. It is a major area of litigation because French law, which is now codified in paragraph 13 of that article, but there were a bunch of decisions by the ECJ starting 2015, but there was a major decision in 2021. And the ECHR imposes some form of notification to the owner of record and an opportunity to be heard in court. There's a very important concept, and I think it is a little bit different from the German law that was just explained. Good faith in this context means not knowing that he or she was not the true economic owner. Anglo-Saxon lawyers would say the beneficial owner of the asset. This is something that we have clarified fairly recently. There's a case from June 28, 2023, and that's very important because it does not necessarily mean being informed of the defendant's criminal activity. It is enough to overcome the presumption of good faith that you know that you're being used as a straw man or a straw woman. So typical example, a shell company controlled by the defendant is not in good faith for purposes of that analysis. And we currently have a case that's due to be rendered in the coming weeks on how you go about appreciating that when the assets are put in the name of minors. So the second category of assets subject to confiscation is really conceptually one of the most important. It's those that are the object or the direct or indirect product of the offense. This is the focus of the modern law of confiscation, obviously. It doesn't mention ownership, but of course reserves the right of the good faith owner. Confiscation in this heading is limited to the part that is the estimated product of the offense. To that extent, there is no need to demonstrate that confiscation was proportional, which you normally need to demonstrate to order confiscation. But you need to take into account that the defendant may not have benefited from the full amount. This is something that the Americans would call disgorgement. You are limited to what the defendant actually benefited from. And case law has had to determine what the product is, and it is now settled on the notion of economic advantage. So for instance, for tax fraud and laundering of the proceeds of tax fraud, it is the amount of tax avoided. It is not the full amount of the funds that were not reported to the tax authorities because you're not taxed at 100%. The same thing goes for social security and employment contribution fraud, except that we have just decided that this also includes the lower salaries and or illegally long working hours. If you're, for instance, using people that come from parts of the EU with different working conditions, or simply completely illegal workers, which of course seriously increases the amount that can be confiscated. So for these two headings, there's a brand new law from June 24, 2024, which will of course only apply to offenses committed after it enters into force, but this has made confiscation mandatory for the previous two items. It doesn't need to be justified, except that the court will have the possibility to explain away confiscation based on the circumstances of the case and the personality of the defendant. If we didn't have that second proviso, it would likely be unconstitutional because French law has a constitutional concept of the so-called personalization of the penalty. So automatic penalties are suspect, some of them are tolerated, but this would not have flown for confiscation. Now we come to the third category of assets subject to confiscation. It's those that the defendant or the owner, when put on notice, could not explain how they were acquired, which is great, obviously. But that one only applies if the only if the underlying offense is a major felony, what we call a crime under French law. And crime is anything that's punishable by 15 years or more, or a felony punishable by 5 years imprisonment or more, and said offense has resulted directly or indirectly in profit. It also requires that the person in question be questioned about the asset during the investigation and asked how it was financed, how it came to be part of their assets. Otherwise, you cannot use that heading. It is quite logical because this is a provision that relies upon the fact that no explanation was provided. So they need to be put on notice that they need to provide an explanation for how that asset came to be. Now, the fourth asset category is what we call general confiscation, and it can go to up of all of the defendant's assets. Big difference with the other ones. This is limited to offenses that specifically set forth this penalty. Article 131-21 just sets forth some procedural guidelines. A key offense for that is money laundering, which, as you know, money laundering is how you can catch a lot of people who have suspicious assets. So that's set forth in Article 324-1 of the Code Pénal for the definition of money laundering, and Article 324-7, number 12, for the penalty. This is obviously very important because, like most European countries, France has the so-called money laundering presumption, Article 324-1-1, which presumes that an offense was committed when the underlying facts of the transaction are such that they can only be explained by criminal activity. So when you have somebody who's living in a villa that is held by a string of shell corporations, that would be a prime example of how this works. And likewise, this includes assets that the defendant has the free disposition of. Because this is an extremely strong penalty, the court must sua sponte explain how the penalty is proportional to the crime that was committed. I will pause here for a couple of seconds to see if there are questions about this early part of the presentation. No questions? Okay. So some practical considerations. We now allow confiscation by equivalent, so which is something that's very important in practice. For instance, you know that the defendant has used the proceeds of tax fraud to buy a villa, and before it can be seized, the house is sold and the money is in escrow with the notary public. You can seize the money with the notary public. This is now possible for all types of confiscation, all items, and it can be of an item that is of greater value than what can be confiscated, except, of course, that then the difference will be returned to the defendant. So again, very, very important practical consideration, because it's due to the rules that I've explained. Since you can't over-confiscate, it is important that you can confiscate whatever you can find in the defendant's assets. Now, the other really important practical consideration is the role of the agrasc, which is the French acronym for the Confiscated Assets Management Agency. One of the things that the legislator noticed in the late 2000s is that the people were having trouble confiscating, because you could, for instance, confiscate a house, but you had to go through all of the civil seizure rules. And there was another problem, is that what do you do with a house? And so the agrasc was created to take care of all of that. So I'm not going to go into the details of how they get involved, because this is way too technical. Just know that we obviously have a dedicated body of rules regarding the seizure of assets and sometimes the sale of assets during the investigation. But know that we have an agency dealing with that. It is staffed by administrative personnel and French magistrates. Just to give you an anecdote, I was on the panel that confiscated a bunch of Rifat al-Assad's assets. Rifat al-Assad was the uncle of the just deposed leader of Syria, and had illegally accumulated a lot of assets in Paris, which were confiscated. The confiscation was made final. One of these assets is a very fancy building in the 16th arrondissement in Paris, where he had a swimming pool illegally built, and the swimming pool is leaking. So guess who is dealing with that? One of my former colleagues working at the agrasc, so he wasn't terribly happy that we had confiscated that particular building. But this is just to give you an idea of how those practical considerations matter. Another thing that they do is that they provide expertise to the investigators and magistrates. You can call them if you don't know whether something can be confiscated, how you should write your decision if you're a judge, the final part of the decision, so that it will be easy for them to act on the confiscation. Another thing that they do is that there's a provision that allows the victims to get their damages paid on confiscated assets, and they take care of that as well. It used to be only in Paris, but they have set up field offices in major French cities, so Marseille, Bordeaux, Lille, so that confiscation is not only something that you do in the big major cases that are tried in Paris, but also in more common cases where you're not talking about millions of euros, but just hundreds of thousands of euros. So that crime, even medium intensity crime, does not pay. And obviously, since France has, as you know, budget problems, the state is very, very happy to have that. So now some statistics to give you an idea of what we're talking about. During 2023, 1.4 billion euros were seized. Confiscated assets turned over to the state, 175.5 million. There's obviously a big difference between the amount of assets that are seized and the ones that are turned over to the state, because first of all, major investigations tend to be very long in France. They typically take between 5 and 10 years, and the most complex ones definitely tend towards 10 years, from the initiation of the investigation to the final decision, because people will go all the way to the Cour de Cassation in these. To give you an idea of how much they have in the bank, 2.2 billion euros on the agrasc's bank account, up from 1.7 billion in 2022. They have seized 731 items of real property, and they have sold for 19 million euros minor assets, some of which have been turned over to the police and judiciary. And it has become quite common for assets to be sold during the investigation, with the product of the sale being held in escrow until the proceedings are concluded, which often is in everybody's interest. It's in the interest of the agency because they don't need to hold on to it for too long. And sometimes even the defendant, who thinks he can get part of it back, will have an interest in the property not deteriorating, because the AGRAS does what it can. But when a real property is left unused, things can be, they deteriorate and everybody loses money. So that's all I had. I purposely did not want to go too far into the technical details. But if you have questions, I will be very happy to take them.
Can you hear me now? Yes. Thank you very much, Mr. Michon. Currently, we do not have any specific. We do have analysts waiting for their delivery, and please remain fast. There will for sure be. So with us, we have Riccardo Fiore, who is from the Central Service for Investigation of Organized Crime, the Finanza. Mr. Fiore, recently you've been discussing Guardia di Finanza. Also in Montenegro, our officials mentioned it and referred to it because it's a lot for you, they say. And this is a model that could potentially be applied in our case when fighting corruption and organized crime. You kindly, in the remainder of your presentation, explain how, and you see that this could be also the model that could be applicable in our case as well.
So, good morning, everyone. Distinguished authorities, ladies and gentlemen. Before starting, I would like to thank you for the invitation addressed to Guardia Finanza. As one of the most important and specialized economic police involved in the fight against organized crime, that have the honor and the privilege of representing in this important event. I'm Captain Riccardo Fiore, and I work for ChristianHaßelmann, which is a central service on investigations on organized crime of Guardia Finanza, which is based in Rome. The role of the central service is to coordinate the activities carried out by the various departments that are part of the central service to ensure effective and adequate investigative support through the use of specialized units to the departments spread over the Italian territory and engage in the fight to organized crime. In addition, our departments analyze the criminal phenomena and identify the individual targets to be submitted as input to the territorial competence units of Guardia Finanza for further studies and developments. So the mission of the Central Service is to support and strengthen the action of the competent Guardia di Finanza local units and their mutual cooperation in preventing and combating organized crime, terrorism, and other forms of serious crime affecting Italy and from Italy to member states of the European Union. So the tasks of the Central Service of Guardia di Finanza are ensure investigative connection and information liaison of activities relating to organized crime and international terrorism, conducts operational and tactical analysis, develops operational projects, and later on I'm going to talk about a special project called Molecular, which is very important in order to do the asset investigations, responds to requests and carries out delegated investigations by the National Prosecutor's Office, and last but not least, keeps operational relations with the National Anti-Mafia and Anti-Terrorism Prosecutor Directorate, which is based in Rome. In Italy, we have, let's say, 3 different mafia, at least the 3 most important mafia. We have Cosa Nostra in Sicily, we have 'Ndrangheta in Calabria, and Camorra in Naples. Mafia change a lot. Mafia criminal organizations change a lot during the years. We have an idea. We had, sorry, an idea of mafia which was a rural mafia, which was based, as I said, in the south of Italy. Nowadays, it's not anymore like this. We have mafia, a criminal organization in general, spread all around the world, especially in the richest country, but not just in them. And so we can say that historically, mafia organizations have shown an increasing attention to the profitable smuggling of fuels and petroleum derivatives by virtue of the considerable economic advantages deriving from the possibility of placing products on the market at lower prices, also thanks to a complex mechanism of VAT frauds. Also, we have illegal gambling, which is often linked with organized crime. For a business or business-like manner in which the owner or boss organizes his associates into division and runs illegal gambling for large profits. And from our investigations, we understand that the most common criminal method in this criminal area, involve altering slots through hardware or software and establishing illegal sites abroad aimed at evading customs control. Moreover, criminal organizations seem to consider infiltration into administrative and management area of local authorities of the huge importance to ensure the financial flows associated with the execution of public works and territorial development plans. This circumstance determines more and more often the dissolution of numerous municipalities because of the influence on local administrations by mafia associations. As I said before, the structure of criminal groups have been changed during years, from a traditional form of crime to one that is more business-related set up with an entrepreneurial and managerial mindset. Nowadays, the most structured mafia groups do not use their profits to finance illegal activities, or better say, they do, of course, because they invest their money also in drug trafficking or other illegal activities, but they also invest them in legal economy. In particular, mafia-style organizations show a growing aptitude to carry out their illicit activities in those entrepreneurial areas where the possibility of laundering and improving the massive liquidity accumulated through traditional criminal activities such as drug trafficking and extortion, for example. That is the reason why our main investigative goal is tracking criminal infiltration in the economy, find and seize the illicit assets. So it's necessary to carry out economic and financial investigations which regard the financial position of a suspect, the reconstruction of the property of the asset, and the identification of how the assets have been accumulated over time. From our investigations and from my experience, criminal infiltration into the legal economy can take place in 2 ways. When the company is a victim business or when the company is a complement. When there is a complicit entrepreneur is the one who has entered into a mutual relationship with the criminal organization aimed to produce advantages for both parties, while the victim is the entrepreneur who does not want to come to terms with the criminals, but suffers the imposition and the related unfair damage. Moreover, with regard to the irregular awarding of tenders for the corruption, the criminals groups keep on consolidating a network of mutual relations aimed at infiltrating local administrations to facilitate the assignment of works and supply of services. In this way, criminal groups can get both the control of the territory and the expansion of social approval, also through the help of accountants and public officials. And this is very important because the power of a criminal group, and especially mafia organizations such as Cosa Nostra or 'Ndrangheta or Camorra in Naples, is the control of the territory. Moreover, it's important also to say that nowadays mafia organizations make a residual recourse to violence. Nowadays, it's like 32 years that prosecutor Giovanni Falcone was murdered by Cosa Nostra in near Palermo, in Capaci. Well, from prosecutor Giovanni Falcone, the judge Giovanni Falcone, we hereditate his famous quote, "Follow the money." And from that moment, mafia, more specifically Cosa Nostra, understood that it's not important to fight against the country, because the answer of the country against Cosa Nostra or mafia organization is going to be stronger, and it won't be good for their business. So moreover, I have also to say that with regard of the irregular awarding of tenders for the corruption, the criminal groups keep on consolidating a network of mutual relations aimed at infiltrating local administrations to facilitate the assignment of work and supply of services. It is also important to speak about assets investigations, and now I would like to, before saying what we as Guardia Finanza will do, I have to say what is the framework that we have, that we work. In this regard, I think it's very important to point out that Guardia Finanza investigations identify the illegal financial flows or mafia companies or assets illicitly accumulated through traditional investigation techniques, such as wiretapping, for example, and a parallel or consequential economic and assets analysis of the collected evidence. So it's very important to do both things, the traditional investigations and also the, let's say, the economic investigations. In order to size any assets related to criminal organizations, Guardia Finanza analyze different aspects that involve a specific target. For example, the standard of living, the financial resources, the assets, and the economic activity of the subjects investigated. The standard of living is the total financial capability of the suspect. For example, luxury goods such as cars, boats, aircraft. For what concerns the financial resources, we have the income produced and preserved, such as securities, currency, money, and income deriving from capital gains. Assets are such as property and furniture, for example, and the economic activity are income production activities. By analyzing these items, it's therefore possible to obtain a full picture of the static condition of the subject to start a patrimonial investigation under the static aspect referring to assets currently owned and the dynamic aspect attributable to the sources of income generation through which wealth has evolved over time. But now we have to know what are the legislative tools that Guardia Finanza can use in order to confiscate these assets, and what are the tools used in Italy. With a series of regulatory interventions, the legislator has progressively flanked ordinary forms of confiscation with other extended confiscation. Hypotheses based on mechanism of evidentiary simplification, which relieve the prosecution of the burden of proving the illicit origin of assets belonging to persons involved in criminal organizations. It is therefore possible to identify the main confiscation hypotheses that can be used to contrast the assets of criminal organizations. In particular, in Italy, we will have the ordinary confiscation, which affects the the assets that are directly linked to a crime. Confiscation for equivalent, when the price or profit of the offense cannot be acquired, allows for the confiscation of assets that are in the offender's possession for a value corresponding to them. Last but not least, disproportionate confiscation, that affects wealth that is disproportionate to the declared income of people convicted by some specific crime, but also to the people that belongs to their families and relatives. Moreover, even extended criminal confiscation and confiscation for equivalent can be traced back to the awareness which has matured over time of the difficulty of reconstructing the specific origin of the considerable and unjustified wealth accumulated by certain categories of subjects, and of the need to avoid the pollution of the legal economic circuit with economic and financial resources of illicit. And now I'm going to talk about what Guardia Finanza do in order to contrast and what we developed. So in order to improve the effectiveness of asset investigations, my department, in collaboration with the National Anti-Mafia Directorate, has created a computer program called Molecola, which is a milestone among the numerous initiatives of Guardia Finanza aimed at the development of operational information technology in the fight against organized crime. Molecola is the investigative tool we use to carry out asset investigations on the individuals who present the subjective condition required by law, which means which are the people that are convicted or investigated for serious crime or socially dangerous. It works basically in two phases. The first one is to collect data, and the phase two is uploading the data into the program. We get the data of a person or company under investigation from Guardia Finanza database that are basically policies database that every police force should have. Like, for example, a database that contains tax data, for example, or a database that which are put the vehicles public registers, or for example the police force system where we can find details about crime reports. All these informations enter into Molecola will then form a database of the investigation in which an ET file for each subject under investigation will be created. In particular, the system's working process provides a first step of collecting all the information useful for the development of the investigations, such as personal data, family ties, relations with natural and or judicial persons, police and judicial records, information on assets, income and financial data, or relevant to telephone and internet subscriptions. This information can be collected during the investigation or obtained from the database used by Guardia di Finanza. As a result, Molecola processes and automatically analyzes the data and give us warnings about both the subjective and the objective condition for asset seizure. Subjective condition means that the person has been convicted for serious crime, and objective conditions means the person has goods that can be confiscated. Once the data upload is finished, we can obtain the printout of standardized reports which summarize the information collected. Once we get this information, we can provide an investigative report to the public prosecutor, showing goods that are in possession of person under investigation and all the links that this person has with other people, even family members. And before finishing, I would like just to say that nowadays, as I said, criminal organization, particular the Italian mafia, such as Cosa Nostra, 'Ndrangheta, or Camorra, are not just based in Italy, but as I said before, they are spread all around the world. So I think it's very, very important, the cooperation between police forces, between Europe for sure, and also between Europe and the world. So we will be, as Guardia Finanza, very happy to, let's say, help our Montenegrin colleagues in order to improve their techniques, the assets investigation techniques. And also we will be very happy to show them our program called Molecular, which for us is very, very important in order to contrast asset investigations. Thank you again.
Let us hear the last speaker, last but not least important, Jovanović, investigative journalist, investigating corruption and crimes. I want to ask you if it is difficult to do the stories about this, given that you come from the system, that you don't come from a system that is similar to ours. Could you tell us what are the stumbling blocks or impediments that you encounter in your investigation? My presentation will be drastically different from those of previous speakers because I am not coming from judicial or police or investigating institution, and I don't do the stuff that the previous speakers are experts in. I do what I follow. I keep an eye on public officials together with my team. I check their property, how they've acquired property, how they've acquired assets, and what happens when we find something and how the institutions react or not react in this regard. I'm speaking from different standpoints as watchdog organizations such as ours is, and I'm a journalist there. I keep an eye on what's going on, and it's very difficult to do this as the situation in Serbia is such that it carries more serious and complex, less transparency. Institutions are arrested institutions. There is no reaction from institutions. It's not easy to get information from institutions. It used to be so simple. We would just request an information, and today we are not relying on just a letter on a paper. And the Institute of Commissioner, even the Institution of Commissioner, to whom we could complain if we don't get the full access to information, has been instrumentalized and doesn't work in the interest of citizens and the interest of all of us. I want to present what KRIK is. For those of you who don't know, we are a non-governmental organization, actual association, established some 10 years ago. And it was established by a couple of us, the journalists who have made a web portal, designed a web portal, and we place the information and stories about high-profile corruption cases. We investigate or look into their cases, look into their connections with criminal organizations, crime, and we report about all of that. As we talk about and we speak about assets and proceeds, I want to say that we investigated assets of public officials. We did that for Alexander Vučić, his assets. He tends to present himself as the poorest president. And we investigated his property, the properties of and assets of his closest members of the family. And it's quite logical for us to, yes, criminals tend to transfer property onto third persons and persons closest to you. So when he presented himself as such, we decided to do the investigation straight away. we made a database of all politicians, and we released it in 2016. So it's been working well, and we've been exploring for quite a while. So we extended the circle, actually the target group. We started with public officials of national and local level, but we decided to go beyond, and we cover judiciary officials, judges, and we made a database of all judges, and we explored and investigated their properties, their assets, and to find correlation between the cases where they were involved and the acquiring of property, to make a link to connect these two. So what we found out is that representatives of the officials couldn't explain how they purchased their real estate, some apartments, and so on. The biggest case that it might be known to all of you, and this is just something that KRIK was became most famous for, is the case of Minister Volin and his aunt from Canada. We have come into possession of some documents because in 2016 we had a good agency for free access to information, and we got the papers from them that Volin purchased an apartment costing 250,000 euros. And he couldn't explain to the anti-corruption agency how he reached to buy such an apartment, how he got the money. He said that he got the money from selling the previous one, but the agency established that it would be too little, that he couldn't afford, as he sold the first flat for 40,000. And he couldn't explain where he got 200,000 euro, more than 200,000 euros. And then he wrote to the agency saying that this was the money borrowed to him by the aunt of his wife, who lives in Canada. The agency never managed to come up with any information, and this case became pretty big. There was no trace that the money came from Canada, that it was transferred to Canada to either Volin or his wife. We couldn't see the money flows and transactions, and Volin and his wife didn't report anything to the customs if in case they got the money in cash and that they have brought the money into the country in the form of cash, of course, because you have to report any amount in excess of 10,000 when you are coming to Serbia. So there was no evidence that he got it from Canada. It comes to Volin couple. And that is why the agency initiated the case, reported a case on the basis of doubts, reasonable doubts that he got the money from a legitimate source, illicit source. At that time, he was the head of the Kosovo and Metohij Commission. And that during that time, there was a very important and very big purchase that was done under the procedure that was declared classified. And we correlate and we make links between this transaction, this purchase, and the suspicious money that he couldn't explain. As this is a top official, they were supposed to investigate where the origin of money. Nobody does think, prosecutors either. They'll check if there is Aunt Mira from Canada who borrowed the money we gave the money to William's spouses, and they closed the case, saying there is no evidence in the case, and they should take his statement as true. And there was a third prosecutor's office that could make a check if they have reported this. And they never found any problem with that. And the case has been through the entire system. It's an end of the case, and we never learned if there is an aunt and if the aunt gave money to them. If the money was transferred or taken into the country, never mind which one. He breached the law, he violated the law, and he committed a criminal offense. He tried to get information from Wulin. He didn't want to talk to us, but we managed to ask him how come that the money came to the country. He didn't report anything to the customs, and there was no transfer. He explained that he would bring the monies below the 1,000 euros, and it would mean that he had to travel to Canada for some 10 times in order, and again to violate the law by doing that cumulatively. Our institutions have once again demonstrated that they don't investigate the assets and the origins of assets of our high officials. We've been talking about that. We've been investigating. Unfortunately, there was no investigation, and no one has checked, and no one has investigated that, and nobody checked the property of high officials. And then even if they can't explain the origin of that, nothing happens in Serbia, nothing happens. They are even rewarded by getting some major positions in the government. The other case that we had, that was not finalized, but fully ignored, was the case when we investigated judges, and we found out that the appellate court judge, together with his wife, who is also a judge, owns property that's proportionate to their income.
We've discovered that they have multiple apartments in Belgrade and also outside of Belgrade, and that the judge also took part in one investment in the Koper region, which is the most well-known tourist destination in Serbia, where prices are the highest when it comes to real estate and tourist centers and the mountain as well. We've also calculated the number of years. So roughly what we did was the following. Since we knew the income of the judge and his wife, having in mind that they are public officials, and the information is submitted and declared with the Agency for Corruption Prevention, and we also had the assessment when it comes to real estates, the market value of the real estate. So we were able to calculate that this couple needed 25 years in savings from their salaries, so as to be able to purchase the assets in Belgrade and elsewhere in Serbia as well, which is incredible, of course. So we published that report as well. And the profile is in the database where you can see the overall assets. We also published this story, and we did expect that at least the Agency for Corruption Prevention in this case would do something about it, because we were able to see what they did in the case of Mullen, or actually more specifically that a serious investigation was carried out within the Agency for Corruption Prevention. However, in this case, it did not occur, which means that when it comes to the judge and his wife, the agency did not react. The agency, in recent times, typically assists officials if journalists discover that they were hiding their assets. So if this comes that it's undeclared, that a public official did not declare the assets to the agency, but this is a misdemeanor, practically speaking, actually breach of law to be more specific. And when the journalists published the story about the public official hiding the assets from the agency, then overnight the agency changes the information within the record, which is publicly available piece of document, and then they say, no, the journalist made a mistake. All the information has already been provided within the official records. So we had a situation when overnight the agency updated, literally overnight, their records so as to show that the public officials are not in breach with the law, even though they were discovered. This has been discovered by the journalists. In the case of the judge, no one reacted. The agency did not react. Prosecution did not react. They typically declare themselves that they say they usually it's not their competence, and this is the same model that various other authorities do. They just initiate the proceedings so as to show that there is some kind of investigation going on, but practically, in reality, nothing happens regarding this investigation. It's only open for some time and it closes. And this is what is shown to the public, that something is being done and investigated. However, nothing in reality happens. Now, what are the consequences? Because no one is held to the account. At least this has been the case in these two cases I shared with you. We are the ones with consequences. Maybe I'm not using the right term when I say this. However, it happens that because of what we do, and we have serious problems. And the largest number we had to face with recently are slap lawsuits, and we are overwhelmed with these. We have 16 ongoing cases, such cases. Why am I mentioning this? Because 2 were initiated by a judge after publishing about her assets within the database. She claims that we've published personal data, although no personal data have been published in the sense of personal data recognized under our law as such. And we did not jeopardize her security in any way, as she claims. She claims that by declaring the asset that they have, practically, we assisted the criminals to locate her. Specifically, this is a judge dealing with the organized crime case. So we assisted criminals to locate her, and this brought her and her family to a great danger. What we published regarding the data in the database doesn't have anything to do with what was mentioned in the action brought by the judge, because we did not publish the addresses, neither the parts of the town or cities that could be easily recognized where someone lives and identified. So we published basically parts of Belgrade. If we are talking about New Belgrade, this is a large section of Belgrade, or certain neighborhoods that are large, and there is no possibility whatsoever to precisely determine where the assets of a certain judge or public official is. And we are very careful about these matters because we're talking about serious matters, and we do not wish to bring anyone into a dangerous situation and to jeopardize their security. However, the situation is such that the judge in the action made some claims which are not true, and what's concerning, and it can also be dangerous, refers to the 2 points. The first point, the judge, apart from the civil, also initiated criminal procedure. So it's not that they're only requiring financial recovery for damages, but also requesting jail 9 months per journalist, the sentence. And from the other hand, she also requests prohibition of the professional activity as journalists in the future, which is terrifying, having in mind that at least as long as I have been a journalist, we haven't had a similar situation in which a public official requested for that. From the other hand, and the second important item and dangerous in our opinion, especially with reference to independent journalists, is the following. The judge brings the action and the judge will also judge us at the same time. So a judge that is close or perhaps not that close to the judge that initiated the case. We will see how things will go in the future because the proceedings have been just initiated. But you know how it is when you have a situation that when you have an appellate court from Belgrade judge from the Special Department for Organized Crime, when she brought the action, her husband is attorney at law, so they made a joint action. And from the other hand, you have colleagues, their colleagues who need to make the decision. It needs to be just independent and who have some kind of respect towards their colleagues than journalists. Because unfortunately in Serbia, I mean, the situation is probably similar in other countries, but recently journalists in Serbia, especially those focusing on investigative work, have been depicted as enemies, and we are under heavy pressure from the side of the government, not only when it comes to these actions, but also because of discrimination. They are trying to present us as foreign agents, traitors, and they put us in a very unsafe situation even. And we had cases when the media campaign against us lasted for a month even. And when I say the media campaign, I have in mind that in tabloids, especially Informer, this is the name of a tabloid from Serbia, they published falsehood about us for a month. And this happened at the time when there was a war against two clans, drug dealing clans, and they even claimed that we are working for one of these clans, criminal organizations, which of course brought the whole organization that I represent to danger. So we have a glooming situation in Serbia, dark situation in Serbia, compared to some other examples that we were able to listen about where there is a certain kind of fight and struggle and progress even. I believe that the case in Serbia, unfortunately, currently is not such, and we cannot hope for a huge progress, at least when it comes to the freedom of media and expression. So this is the point of view that I'm referring to. So I wouldn't go into further details. I'm here available if you have any questions. Bueno, thank you very much for your presentation. I do think we have some questions. Do we have the microphone ready, please? For the gentleman in the first row.
I have a question. I'm working for the FIU. I have a question for Mr. Fiore, if possible. One short before break. We're looking at Italy as an important neighbor and very often as a role model for different stuff. This is one of the things that we're looking at you as a role model and how you develop and set up your system regarding illegal property gain through the different circumstances, let's say. When we have a criminal procedure, that's clear. I mean, a mafia type organization or religious organization, that's not the question. What bothers us is when you have a not illegal, but you have a property that can be explained how it's obtained. Can you explain us what you're gonna do or what the Finanza gonna do if you spotted in your neighborhood, in your street, nice. Anyhow, let's say without job or maybe with a job, we multiply it down to its monthly salary can be obtained by this. Can you explain us, that's what mostly bother us. Can you explain what you're gonna do practically as a police and what if you know, if not, that's very important. You know what the prosecutor gonna do possible your work information. Thank you.
Okay. Thanks for the question. And I will probably do two things. First of all, I didn't tell you, but in Italy we have the penal code and also a legislative decree 159 of 2011, which is called the Preventive Measures Decree. So it means that even if I don't have any, let's say, criminal proceeds, I can write a report to the prosecutor of a person that is social dangerousness. So because he has a lot, as you said, he has a lot of goods, he has apartments, cars, but apparently he didn't do any crime, apparently. So I can ask to the prosecutor, and then also the prosecutor will ask to the judge, using this criminal legislative decree in order to confiscate these assets. Otherwise, if I find, as you said, a person on the street that he has a lot of goods and I would like to investigate on this guy, the only way, at least in Italy, is to work with the prosecutor. Because in Italy, the, let's say, police forces can't do a lot. So, alone, without the help, let's say, of the public prosecutor. So in this case, I would probably try to write a report to the public prosecutor in order to ask an hypothesis of money laundering, or maybe an hypothesis of this guy is has a lot of goods because someone else gave him these goods. And in Italy is the Article 512 of Penal Code. And then I will start doing, as I said before during my presentation, both traditional investigations. So I will ask him to the public prosecutor to use the tools of, for example, wiretapping, and also do the asset investigation. So try to understand all the goods, when these goods were bought, how these goods were bought, and also if the goods are used or are using by this guy, because probably I am the owner of a Ferrari, but the Ferrari is used by another guy who has a lot of crimes, a lot of criminal proceeds on in the past, for example. So this is an important element that I can size the Ferrari, because I'm saying the Ferrari is not of the guy that bought it, but is the guy. The Ferrari is owned by the guy that is driving it. And this, for example, this case, the Ferrari was used by a mafia clan member, for example. So I would choose this both strategy, let's say. I don't know if I answered your question, if it's okay.
Do we have some additional questions? If this is not the case, I would have one brief question. And if you can provide a very brief answer, Mr. Haßelmann, you mentioned that the law in your country prescribes that the assets can be confiscated from third parties or persons related close to the perpetrator itself. Now, when talking about the practice, what is your experience? How important is this? And how often does it happen that the assets are concealed by transferring it on aunt, wife, daughter, and in similar cases? I'm asking this because specifically in Montenegro, we had a lot of remarks when it comes to deleting this provision from the law. Thank you very much for your comment.
Yeah.
Thank you very much for your question. This is very important. This provision is very important for us, especially having in mind when this is applied to economic crime. This is a rule in economic crime that the perpetrator is not the beneficiary or the one who profits from the criminal act, but a business entity or a legal entity that was used for the evasion of taxes, for example. Hence, we can include this legal entity with the action of confiscation because it acquired the proceeds of crime. Without this legal provision, we wouldn't be able to perform the confiscation. In cases when the assets are transferred to relatives or third parties, in my opinion, and based on my experience from the area of the criminal organized crime, this is a daily work that they do, which means that the perpetrator, a mafia member, by rule, does not have any incomes and assets. He can even get social welfare from assistance from the government, claiming that they don't have enough resources and that they live a poor life. And then you realize that the assets is somewhere else, concealed with the aunt, uncle, mother, wife, that they are very rich. And thanks to this, you have the possibility by following the money, as mentioned by Mr. Falcone, to see the earnings and where it ends when it comes to the money flow. And if we can establish this, and if we can prove that the assets, the money obtained from the criminal acts is transferred on their relatives, it gives us the possibility to directly act upon the third parties and persons without this legal grounds. The confiscation of assets wouldn't make sense. It also wouldn't be possible. So this is of utmost importance for us, especially when fighting organized crime. Thank you very much. It was very useful to hear these comments and experiences and everything that we discussed during the past 2 hours. We heard some experiences that we can for sure apply in the context of Montenegro only if we wish so. Now we will have a very brief coffee break, after which we will have the second panel, during which we will hear from the representatives of local institutions their point of view regarding the legal framework and what are some key challenges in its enforcement. So see you soon. As announced, within panel number 2, the discussion will be focused on legal framework in Montenegro, the key challenges and barriers in its enforcement as well, in mind in the light of the new amendments that were passed in this area. Social music. It is a pleasure to introduce my interlocutors today, the panelists, Mr. Vukas Radonjić, Special Prosecutor, Sava Laketić, Acting Director of the Tax Administration, and Mr. Mladen Tomović, Deputy President Council of the Agency for Prevention of Corruption. Welcome. Alexander Radonjić, Head of the Financial Intelligence Sector, Police Directorate. Vladimir Radonjić, Head of the Department for Anti-Corruption within the Ministry of Interior. And finally, Dejan Milovac, Director of the MANS Investigative Center. Mr. Radonjić, let's start from you. Within the State Prosecutor's Office, how do you see these new amendments with reference to fighting corruption? In other words, to which extent is the current legal framework is limiting and restricting when it comes to your efficient work? I'm asking this because of the following. With the new amendments that were passed, we have the investigation procedure deadline or time framework has been reduced from 2 to 6 years. So about it. The capacities of the State Prosecutor's Office are limited, and there is a large caseload currently. Has this measure contributed to the burden on the State Prosecutor's Office, and are we paying for the speed in which the package of the laws were adopted? Thank you very much in advance. Thank you very much for your invitation. I would like to congratulate you since you organize successfully large events such as this one year in, year out, and I'm very glad that the organizer is the NGO that has been recognized in the country as one of the fighters for a democratic society and fighting corruption, and that you also recognize Special Prosecutor's Office as one of the key players and stakeholders for an event such as this one. We were panelists last year as well, and we were also in attendance as members of the audience. Today, we have the pleasure of being panelists, and I would like to thank you for that. Regarding your question, we're witnesses of the following fact, and this is something that we have declared publicly as well. And this is a well-known fact, by the way, to the citizens who in any way or in any form get in contact with the Special Prosecutor's Office. The amendments to the mentioned law, lack of clarity, and some illogical legal provisions are not the only obstacle for the State Special Prosecutor's Office to achieve better results. We have other challenges that we face with the focus on the working conditions, cooperation with other state authorities, as well as the number of people who are available, not only within the State Special Prosecutor's Office, but also police department, courts, and these are the authorities that collaborate with the Special Prosecutor's Office. And a certain phase of the proceedings are undertaken by these authorities. And the current legal solutions that we have mentioned, that you mentioned, the reduction of the time frame and deadline, I don't know what was the exact intention of the legislature. I don't know if it was the intention to provide for a more expedited procedure, and maybe for that reason, I can understand from that angle that solution. However, I do not understand that we have a limited deadline, so we are limited, and not only us, but also the other relevant authorities engaged in the procedure. And with this, we do not meet what's the point, the substance of this law, to confiscate the assets acquired through criminal activities from which there is no legal proof of origin, actually proof of legal origin. In this regard, we will try to invest some additional efforts, even in this shortened deadline, to achieve certain results that are not sufficient. But another problem we face with is the fact that we do not have enough practice in these cases. We don't have the sufficient number of trained people, experience, expertise, the standard of proving that is accepted in the world and the EU is not the same within the court and the prosecutor's office. And this is something that I will mention later on. But for certain matters for which we thought we have sufficient evidence and proof, that we have the case of the proceeds of crime, the court at certain instances did not accept that as a proof, as a valid proof. So there are multiple challenges we face with, and I'm hopeful that events such as this one, through which we will inform the public what's in the focus of our challenges and pinpoint certain burning issues, will contribute to a more efficient work and amendments, future amendments when it comes to the legislation, with the goal of providing Montenegro with the following, not only to punish the perpetrators, but also to confiscate the assets, the proceeds of crime. Okay, let's sum up. Is it realistic to expect that in 6 months you can submit a request for confiscation that cannot be questioned later on in the procedure? No, I cannot, generally speaking, give you my position on this, but it's a very challenging time frame and deadline, and it's going to be very difficult and challenging to meet this deadline in all the cases that we will have to deal with. Mr. Laketić, generally speaking, recently, and only if we take, for instance, only this conference, on multiple occasions we mentioned finance police, Guardia di Finanza in Italy. Do you think it's feasible to apply the same approach in Montenegro? And in what way could the tax administration could give a contribution? And do you have sufficient capacities for that? Thank you very much. At the beginning, I would like to thank the organizers for the invitation. As someone who has relatively recently been exercising my duties, I would like to thank you for the invitation and for recognizing us as a partner in this process. We have some, at the inception phase, some hopefully very fruitful cooperation with the organizers of this conference, and I'm hopeful that what has been initiated will provide a solid ground for the continuation of our cooperation. Yes, regarding your question, you're right. In recent times, we have been discussing a lot the experience of the Guardia di Finanza, so the financial police, and we are, when it comes to the establishment of this kind of police, we had some certain rounds of discussions with the representatives from the Guardia di Finanza with the assistance of the Italian embassy. We exchanged certain reiterations and documentation, and we've also analyzed the legal framework that should provide us with a model that is similar to the one that is used in Italy. You've mentioned that the challenge of the personnel and the technical problems. The intention of the tax administration is, irrespective of the fact of the current legal setup, to provide the grounds for the future finance police. And in this sense, we will have a sector that will deal with disproportionate assets and taxes in line with the law on tax revenues for natural persons. The tax administration, in accordance with this law, has the mandate for the unexplained wealth to tax up until 80%, which is close to confiscation, as the model is called in the West. So this practically means the confiscation of the assets, and this model is being used most frequently when we cannot prove the guilt, and we cannot explain the manner for acquiring the asset. We do have, we are a shortage of staff, and our administration, there went structural changes in the recent years. In 2021, we had merger, and then another structural change this year. So all these processes present challenges. Job classification plans have not been, HR plans have not been realized and implemented to the fullest, and new appointments have been initiated only in November, the month of November. So definitely we do have some challenges. So these are some of the key challenges we face with, actually. The current state of the IT solution and connection and links with other institutions represents another challenge. I need to mention that we have a very good cooperation with the institutions. However, at this moment, this is done manually, which of course presents a challenge per se. And this also could yield mistakes in our work. And with the assistance of the World Bank, we've initiated the process of the transformation and setting up a new system. And we're right now at the final stage of this process. And we expect that by the end of September next year, we will have the core modules, which are key and critical for matching the system with other and linking the system with other relevant institutions. I'm glad to see that this year we have also an increase of identified cases regarding the tax evasion, the criminal offense of tax evasion, which shows that as a society, we have a better cooperation in this regard. I mean, as institutions, we have a better cooperation in this regard. And I'm glad also that we have a very good personal cooperation with Financial Investigation Unit on a daily basis. We communicate also with the Police Directorate, and we have a daily communication during which we obtain 1 to 5, let's say, requests for joint investigations. And of course, there is the Special Prosecutor's Office as well that we cooperate with. So there has been some progress. The current state of affairs is not good. It's far from ideal, of course, but I believe that we have set certain grounds and that we do not solve the problems abruptly, but in a strategic planned manner. So I'm looking forward also to set the stage for the people who are coming after us. So to prepare a good platform for a good cooperation for them as well. It's not realistic to have the finance police quickly in that form. However, we will have this sector that I have mentioned, the new sector that will serve as the basis for this future finance police. And of course, after the legislation the necessary legislation in place, the finance inspectors will have all the mandate and authorities which are necessary to perform their activities in a similar manner as it is done in Italy. What is the deadline that we're talking about here? 5, 10 years? I'm an optimist, so I'm hopeful that we will have the finance police ready by then, and the sector that I referred to that will be in charge of some affairs that will be under the competence of the finance police. So by the end of January, beginning of February, we will establish this unit. For the beginning, we do not plan to employ a large number of people. Most probably we will have 3 departments, 10 to 15 people employed, various professions and profiles, backgrounds, and before the establishment of this finance police, we need to clearly define the scope of activities, with all having in mind that the scope of activities performed by other institutions that are already in charge of certain affairs in this field. So we do have an idea, we have a plan how to reach our goals, but of course we need to think about the details, and one of the key burning issues will be the appoint the necessary number of people, HR support, and we have some support from international partners in terms of technical and legal support as well was obtained. So we will use all the available resources in order to reach the desired model as soon as possible. Thank you very much, Mr. Tomović. The Agency for Prevention of Corruption, practically speaking, ever since it has been established, it has been in the focus of the public, not because of some good results that were obtained. Very often, as the justification for these results, we were able to hear that the stumbling block is, and that what restricts you in this work is an unsatisfactory legal framework. Does the new legal framework and the amendments to the key laws in this area, pieces of legislation in this area, do they now enable you to work more efficiently? And whether we will stop listening to the fact that, let's say, the legal framework is an excuse for efficient results, for yielding also results? Thank you very much for your question. I'll be very direct. The new law on prevention of corruption has been adopted on June the 12th, 2024 of the current year, and it has been enforced for 6 months, more or less. The solutions under this law are worse, it seems to me, compared to the previous piece of legislation in this area. Why is this the case? This is a question for legislatures. Perhaps tight deadlines, in mind the EBAR measures are to be blamed, but the key gap is that for the first time, as of 2006, the statute of limitations for the initiation of proceedings for the competence of the agency have been introduced, with the relative absolute deadline of 5 and 10 years, which in principle means that the agency cannot initiate a case after this deadline. 5 years. And this limits the possibility of further activities to be taken in these specific cases that are already in the focus of the agency. And the second category of cases that, upon the establishment of the new measurement of the agency that was received from the NGO sector, and there's more than 200 such cases, which pinpoint to the breach of law stemming actually that occurred in the period that were longer than 5 or 10 years when it comes to accurate reporting, when it comes to assets cards or property cards and records. This shows that the previous law, the current law, has a lot of gaps when in this limited period, we already faced with certain problems, stumbling blocks when it comes to the enforcement of this law, and the working group has already been established, and we do expect that by the end of December of this year, the preliminary work when it comes to the amendments of the current law will be finalized, which tells you what a problematic solution we have in the current law. And I'm really hopeful that the statute of limitations will be removed from the text of the law. The second burning issue is the following: the data which are obtained within the assets cards of the public officials, as they are defined right now, from one hand, create serious problems and challenges for the agency, and from the other hand, In my opinion, they also fall within the breach and violation of human rights and freedoms, meaning that the public official, as per the current solution, is obliged to declare personal data for related persons. The scope of these persons is so broadly defined that these are all persons with which the public official establishes or has established business cooperation, personal or political relationship. If you have in mind what is the scope of these persons, so these are all the employees with whom you have the business cooperation or personal cooperation and relation. And when we talk about the representatives of political parties, this, of course, covers all the people with whom you have political relation, which means that there isn't a single asset card that could contain or has contained the requested data as of June the 12th, 2024. So this is, again, one of the gaps. From the other hand, even if we had the scenario that the public official wished to declare the requested data, how can he enter this type of data into the card? So this person is automatically breaching the law because he or she declared insufficient or not incomplete data into the card. So the broad scope of this provision and the related persons that I mentioned open the possibility for those who are working with the agency can initiate procedures against certain public officials for whatever reason, which is not the point at the essence of the law, but the point is for the circle of related persons to be limited to a circle that is in direct contact with the public official with whom they have a certain relationship to gain some personal interest. So this is the connection point, the link with the circle of related persons. Another important matter is the following. The law, there was a provision that was deleted from the law, and I'm hopeful that it will be reintroduced into the amended text. And it reads that the agency, as the competent authority, in the case of a suspicion that the assets are transferred to related or third parties, can request from these persons to declare the report regarding their properties and assets. So this is the mechanism we use, and not by default, all of us to enter all types of data, and then the agency can, for example, will not know what to do with the data if we are talking only about personal data. Of course, there's this aspect that they're entering, of course, into the zone of the protection of personal data and the possibility for this provision of the law, operationally speaking, to enter into force. I apologize, but you mentioned that by the end of December, we can expect draft version of amendments. Are you an optimist? And will your suggestion go into the direction to amend the section regarding the statute of limitations? Because if this does not come about, will this mean that high officials, a lot of watches, houses, and so on, because of which this discussion has been intensified, will be abolished? Rightly so. As I mentioned at the outset, as a member of the working group for the amendments of the mentioned piece of legislation, my opinion is that it is necessary to delete from the law this regulation or this provision referring to the statute of limitations. And of course, we will see whether this suggestion will be acknowledged and accepted or not, but I'm hopeful and I expect that it will be. So, from the other hand, I would like to remind you of the following. The current law, the final and transitional provisions, from some reason, contains also the provision stating that the initiated procedures, only in the cases of the conflict of interest, and the whistleblower's reports will be finalized by applying the provisions of the previous version of the law, which means that in all the other cases, when it comes to whatever, the provisions of the new law will be applicable that do recognize the statute of limitations. And in this specific case, this exposed the new management of the agency to the pressure of the public. It's impossible to act upon the applications that haven't been initiated prior to the initiation of the procedure and entering into force of the current law. For this very reason, I do expect that the proposer will have understanding for our suggestion and that we will regulate this matter in the best possible way, that we will repel or delete this provision from the law, and that we will also in such a manner solve another gap, which is the content of the assets card itself, the data that the public officials submit to the agency, as well as the definition of terms regarding related persons and the scope of persons that are obliged to submit reports, the so-called categorization of public officials, and those that, apart from submitting the report, are obliged also to observe the limitations and restrictions prescribed by the law on prevention of corruption. These are some of the key novelties, and that should be crystallized when it comes to the application of the current law. And finally, if we see the results of the work of the agency and analyze them, the results are in terms of the monitoring and transparency of publishing data. If we talk about the confiscation of the proceeds of crime institute or illegal wealth through the misdemeanor procedure by the application of the Article 50 of the law on misdemeanors, which refers to various fees and taxes which are obtained in contravention to the law, in the specific procedure will be confiscated by the decision of the misdemeanor court. They will have to be returned. These are not some significant amounts. We did have such cases, but a question that is of greater significance that was the focus of the attention of the public is the increase in the assets of public officials that cannot be explained. The lifestyle of officials, transfer of the assets to family members and related persons. So in order to reach a certain epilogue in terms of the procedures, the agency can apply and establish the revenues, the expenditures, and to see whether they overlap, of course, with reference to the public official, and there is a certain discrepancy identified in that report, then the prosecutor's office can be informed about it. The second question is, what will the prosecutor's office do with the report if, under the criminal code, we do not have the criminal act of illegal wealth? Which means that prosecutor now needs to ask for the specific criminal act, use of the function, and so on, so as to link the report obtained from the agency with the mentioned criminal offense. Technically, if you want to hear my honest opinion, the possibility for the prosecutor's office to solve this issue ad hoc is impossible. And we are still in a circle in which we have a fact that Montenegro ratified the Convention of the UN for fighting corruption, that the Constitution of Montenegro prescribes for the supremacy of international treaties or the national legislation, and under this convention, it's clearly stated that illegal wealth is prescribed as a criminal offense, and there is the obligation of the countries parties to the convention to incorporate this criminal offense under the national legislation, and we currently do not have it. So this is an open legal question to incriminate the consequence, the repercussions, and not the so-called criminal offense from which the illegal wealth came or stemmed. So this is basically the question of the political decision of each country, whether they will regulate this under the national system. My opinion is that the prosecutor's office would be easier for the prosecutor's office for all cases to process all these cases and prove the existence of the criminal liability and accountability in the case of the criminal offense. However, of course, there is another mechanism available that is adopted by certain countries, which is the civil confiscation of the proceeds of crime, which functions through the system of administrative authorities, specifically by passing a dedicated law or the law on tax administration, in which the tax administration, through a certain procedure, would, not just for public officials, but also for all the persons concerned, without any limitations, initiate certain procedures in which the person would be obliged to prove the origin of the assets. If not, then the percentage of taxation would be up until 75% based on the comparative practice. And the administrative procedure would be finalized in such a manner. There is another procedure in which specialized institutions, such as in the United States, we have such examples where certain dedicated agencies would be established, specifically focused on the civil confiscation through a dedicated regulation and through civil law in such a manner perform confiscation, in which they would have a dedicated agency or institution, or potentially expand the authorities and the powers of the protector of the property interests, legal interests of the country, in which they would perform the procedure and in such a manner perform the confiscation of the assets. My opinion is also these are all good mechanisms available. We need to discuss the potential of using these mechanisms and tools, and we as Montenegro urgently need these mechanisms. And from the other hand, we need to think and consider the possibility of specifically, having in mind the topic is the law on the confiscation and seizure of the proceeds of crime. This piece of legislation needs also to undergo a certain number of improvements and interventions because of the reason that at the earliest stages and at the reconnaissance stage, we need to establish the assets of the performance, potential suspects, and all the related persons. The assets need to be freezed until the end of the procedure. And in such a manner, we would narrow down the possibility of financing other potential criminal activities, and this could facilitate reaching certain rulings and judgments. The system of abolition of persons who are ready to confess the criminal offense and return the assets is also a very interesting mechanism when it comes to the aspect of the speed of the procedure and providing proof and evidence for that. And also having in mind the full abolition if the assets are returned to the full. I believe also this is one of the points and the goals that we need to reach to return the assets to the state budget, and not only to insist on criminal sanctions, which do not always result to the benefit of the country as it was mentioned, as the ones that I suggested. I will have to stop you here. We will have the chance to continue our discussion, but let's give the possibility to other panelists to address the floor and then add something else. Mr. Radonjić, you wanted to mention something about the coordination with the State Prosecutor's Office regarding what was mentioned by Mr. Tomović.
He presented a very important fact that is definitely in the interest of public, and I noted that as being also the media representative for the prosecutor. We had the whole string of criminal cases where we looked into the lifestyles of former officials, high officials, agency, no matter who the head of the agency was at the time when we got the documents that prove that there is a disproportion between the legitimate income and their property. This was submitted to the Special Prosecutor's Office, and our hands are tied because we have to establish the reasonable suspicion and reasonable grounds to actually prosecute those cases based on illicit enrichment after all. So this law on confiscation of proceeds implies that there is a financial investigation all along if there is a suspicion of an criminal activity where the confiscation is possible. And we haven't established that degree of suspicion and degree of reasonable doubt. I don't know if the cases have been finished, but the lack of grounds is something that stops us from doing something about that. And this is an impediment. We have a couple of cases. This will be very unpopular to communicate to citizens. They will be angry about that, but this is something that we have to do because we apply the law accordingly. Once the agency establishes the disproportionality between the income and the properties and assets, we just have an indication. Whether this indication will transform into reasonable suspicion, or probable cause, we are yet to see. In these concrete cases, we haven't managed to find it. And in follow-up to what Mr. Tomović said, even when we have this criminal offense introduced, there is a principle in the law that in order to apply something, you have to have it in the law, so it won't have retroactive effect. So the question is whether all the cases we know and are aware of, whether it is possible to try those and first to prosecute and then to try it. I'm glad that we have initiated this and that we have come to a common ground, not that we have planned it, but we have reached a common ground, especially when it comes to the representative of the anti-corruption agency. We need to have the sanction, but also the confiscation as a part of incrimination. Mr. Laketić, I think that it's not just incident or accidental that we are sitting in this way. I believe that the next case is that of that close cooperation, in favor of this close cooperation. So taxing unexplained or wealth so close to confiscation is something that is envisaged in the tax law. However, it needs to be completed, and we are working already on those amendments. So it is 32nd. We have other speakers, so other panelists. So let's say a bit, Mr. Radonjić. The process of proving illicit property or criminal proceeds entails complex financial investigation. Do you have enough capacity for that? And the European Commission is for years and years on until today criticizing the lack of capacity, is critical about the lack of capacity. Thank you for your invitation. The European Commission is critical about the efficiency of financial investigation. When we speak about capacities for that, let me share with you that we are working in close cooperation with the Prosecutor's Office, and we do that at the request of Special Prosecutor's Office. And FIU does the financial part of that investigation, whereas the other organizational unit looks into the other assets like vehicles, boats, and other stuff. We have a close cooperation. This is good. This is what we read about that. And FIU cannot come out with the results, with the track record. This is our work. This is what we've done, and we respect the hierarchies when it comes to the prosecutorial hierarchy. The results could be better, the work could be improved, but today we talk about this issue and why this topic is still relevant is the fact that the state needs to do something more about illicit properties, proceeds, and we need to come up with a model that will be most appropriate for Montenegro to apply, if not replicate. We have the law in force that is not perfect, however satisfactory. And the law is applicable to a degree. As prosecutor said, there is a need to make some improvements, to do fine-tuning, to extend some deadlines, to do some minor changes that won't be a challenge to apply. So we as the society and the state need to apply it duly and to apply the law as it is in order to confiscate someone's assets. We need to have four agencies for institutions to act in very close cooperation. If we don't confiscate on time, then, or we do it after some 10, 15 years, then there is no use of that in doing that. And we need to cooperate closely and at some point to think of how to fine-tune the model and which model to apply or to close, to choose. And to take on board all the experience of former panelists that presented their jurisdictions. And then, for example, we have similarities in constitutions with Slovenia. So we will have the same problems as they have now. And we can't simply copy-paste. We are so specific and so big difference between us and the models that we heard about. We mentioned Italian, we mentioned American, we now heard about French model. It's true that I have the impression that politicians who speak about it don't like the model. They should go for the results of the model. You can't compare Italy to Montenegro. They have some 900 registered criminal groups. We have 11 that we have registered. And this is particular success in fights against them. But you can't compare a country with 60 million citizens in the country is 60 more in immigration. It is the model and the model that they have. They had lots of debates about that, and they discussed whether the model is good, whether the solutions and models are okay. How can we preempt the situation with someone, third person who is not involved, can't be affected? So we can't copy paste. We have to come up with a model that will be tailor-made to our situation, to our context, and only then when we confiscate and not seize but confiscate, then we can talk about success or that we have come up with a model that we have done. Why can't we have results? If the model is something that we should talk about in the end, I say that we should do better. Our work should be better. I won't be pointing finger at any of the institutions, but the prosecutor and the Directorate for Property, they need to be efficient, to work hard. If it takes us 10 years to complete a case, then nobody is happy. You as a citizen can't be happy with us. So we need to work hard. And as for the model itself, whether to be to take the revolutionary approach or not, it depends. And yeah, we need to maybe, one of the options is the tax law, and that is how we could track down illegal property. And let me say something, even if I'm wrong, even if someone tells me, yes, the Italian model is perfect, who will apply it? The same institutions that should do that job now. this is the tax police. Who will work there? Who you will get to work there? Those are the people who work in the tax directorate. How can you get people? He needs 10, and he won't find more than 5. So it takes a while, and we need to work hard to be very specific, to be very concrete, to go cautiously about everything, and to be realistic. We need to be more efficient nationally with the present solution, and along the way to fine-tune our system. Mr. Tomović, what are the effects of the new rule book on the control of the oversight, and vetting of policemen? There are many policemen who have the property much bigger, assets much bigger than their income. How many police officer are that, and which rank they come from? Hi, everyone. Salute to all of you, and thank you for inviting me to take part in this conference where we exchange experience and challenges we encounter. We, the police organization, police director too. We now have the new rule book on control or properties and oversight of properties and assets and income of the police officers. Is a new piece of a kind of legal framework, and we have created conditions and basis to make this oversight. Unlike anti-corruption agency, we have provided the declaring assets obligation. So all police officers have to declare their assets and income. Also, the real estate where they reside, or a property where they reside, even if it is not titled to their names, and all the artworks, wristwatches, and valuables. As the rule book entered into force on 21st June of this year, and that they were obliged by July this year to declare assets, 3,600 of them, 580. Koliko njih nisam čula? Sorry, I didn't hear the number, how many of them declared. And according to the rule book, we requested from a board of ethical board to give us opinion whether they have breached the code of ethics for police officers. We, with this opinion, the opinion of that commission, we will initiate disciplinary proceedings and inform their superiors to conduct a disciplinary procedure for the serious breach of duty. We have also controlled 1,500 declarations. So what is the serious breach of duty? What are the sanctions implied? Yes, so the sanction is fine of 20 to 50% of the salary. Police officer cannot then be promoted to a higher position in next year or two. That he or she could be put to some lower rank position or demoted, or of course the working contract being dismissed from service. We've looked into declarations of property, and we saw that many of them haven't done that fully. 220 were called for someone to report, and we asked them to remove the mistakes from their declarations. If they fail to do so, we will treat it as they reported wrong data, that they have misinformed the service about that. And the rule book in Article 183, we added item or line 29, which stipulates that if they haven't completely met the obligation from Article 164, they are committing a serious breach of duty, and we could initiate disciplinary procedure. So where are the disproportions biggest, and which ranks have made them, in which ranks do these people serve? We had some 8 case files. The prosecutors will look at that, and the prosecutors informed us what to do. We opened 4 cases and reported those cases. There are some police officers who have done it, didn't report their properties with the anti-corruption agency. 11 heads of police service and 1 low rank police officer are in this group. How big is the disproportion between reported declared income and declared property? We haven't made calculations in terms of monetary values. We saw that they have a couple of pieces of property, some expensive items, and they haven't reported that. So we are now to work together with the anti-corruption agency to compare and to pair those declaration reports and the other reports. When can we expect some outcome? We are to see it soon. We've seen that we have problems with the staffing, with the working conditions, and so as for 4 cases that were opened before the anti-corruption agency, we are soon to have a meeting and to take other steps.
So then we were able to hear from MANS on multiple occasions that the legislation adopted within the limited deadline and timeframe are full of gaps, and we are already paying and reaping what we saw. Do you have any optimism or hope that something can be improved? And do we always have to wait for Brussels to instruct us what we need to do, and then, because of that pressure, to adopt some pieces of legislation that ultimately are not as efficient as we hoped them to be? Do you expect any results in this area? Thank you very much for your question. So, after listening to all the panelists, I would like to answer your question and also to refer to some of the points that I was able to hear from the panelists, especially with reference to the question of whether we need to be pressured from Brussels. Yes, I do believe we do have to be pressured from Brussels, because This is the problem that we face when it comes to fighting corruption. And we did have some procedures initiated, usually prior to the reports in terms of the progress of Montenegro. And this has been the case in the recent years. Numerous cases for some aggravated cases of organized crime were forced, first and foremost, by the political decision, and they ended up by, you know how it ended up, and what were the final decisions. And I'm really sorry to see that in the part of this panel, when it comes to Mr. Radonjić, the opinion is that nothing will be better, that we need to work better. And I would like to remind you that in the past 20 plus years, we've as months been working with the same intensity. When it comes to the topic of this discussion, the discoveries were made by months, and this is something that can be confirmed by the prosecutor's office and police. You remember that numerous reports were sent to the Agency for the Prevention of Corruption, and most of the cases originate from the NGO sector. So I believe that of course, Italian model is not fully applicable, and I agree with that, but we cannot reject just something that has been worked on for a number of years and that we obtain from as a finished know-how and to learn from their good sides, but also their mistakes that were made. And we were able to see the examples from Slovenia and Italian model that they are not just giving compliments to their model, but they also pinpointed to some important lessons to be learned from the mistakes and something to be avoided, of course. But I reject to have this kind of approach that certain matters are not possible, because no one from this table could have imagined that someone as Vesna Medinica would be in pretrial detention and that the procedure would be initiated against Mr. Veljović, Katnić, Jovanović, and these are all persons that were in the focus of the research and investigation performed by MANS. Years before that, it was initiated by the prosecutor's office, I believe your department as well. And before we were able to hear from Sky application that something is wrong or rotten the state of Denmark, MANS voiced the opinion that it's very important for the red flags to be made. The difference between declared and the actual assets should be, discrepancies should be red flags, pinpointing to certain deviant behavior. MANS has been very successful in detecting these when it comes to Vesna Medinica case. Years before that, she was sent to pretrial detention back in 2012. We also pinpoint to the assets of Vladimir Veljović. And as we were reminded back then, Mr. Katnić accused us that we even made a drawing by drone of the concerned asset. And I do agree with you. It is very challenging in the existing environment to yield the better results. I mentioned this during the previous conference. It's challenging to conduct investigation, whether you are a state authority or NGO. Of course, state authorities have larger powers and capacities. But we have the situation that previous state prosecutors have two unique citizen numbers, an official one and the unofficial one to which certain assets are registered. And it's very difficult to monitor the situation when the system allows you to create your assets not on Seychelles or Bahamas, but in Podgorica, when you have the assets under the unique citizen number, which is not public. So these double unique citizen numbers were a serious challenge, and we didn't see any serious efforts from the government and authorities and public officials to solve this problem. And of course, it would be naive to think that we do not have any similar examples in cases of organized criminal groups. I would just like to reiterate something that was mentioned to this drastic reduction in the deadline for the investigation from 2 years to 6 months. I do believe that this legal solution has its supporters in Montenegro, and I do believe that they are not from the rows of honest businessmen and politicians. We were able to see that in the case of the smuggling of tobacco products from the Emirates to Montenegro and investigation in such a case needs to happen also outside of the borders of Montenegro, and this money, the money obtained from these activities, is already being invested in certain countries. There are some assets that are not investigated only in Montenegro, but also other destinations, so at the safe havens in terms of taxation around the world. So within the 6 months deadline, it is something that was introduced so as to prevent some serious and complex investigations and not to yield the results apart from the PR marketing and return of the assets to the citizens, especially with reference to the smuggling of cigarettes that hasn't been seized or actually hasn't been stopped in Montenegro. And we are talking about millions of euros that organized criminal groups have as a turnover. Now, I forgot your question, Mariana, your initial question. So this was all a digression that we were able to hear. Now, do you recognize that we were able to see a pessimistic attitude of Mr. Radonjić? But can you identify, recognize true dedication to change things after such legal solutions that were adopted? Do we have some results with the chief special prosecutor? But is this enough? Well, even during this panel, in iterations between Mr. Tomović and Mr. Laketić and Radonjić, I do believe there is this joint identification of the gaps. But the executive branch, the legislatures, political parties, the new ruling majority do not hear this voice, even though it's articulated in the public. But I'm fearful that it is being articulated, but we do not have some specific results. So I am optimistic in terms of yielding results when it comes to the processing phase, even though of perpetrators, although they are limited currently, and they need to be followed by the financial investigation and final judgments and enforceable judgments, of course, and this is something that is lacking currently. We cannot talk about reformed judiciary and the Judicial Council as the institution continued to reach decisions that additionally complicate the narrative about the reforms. When you have a look at the stakeholders for the reform, are those that are mentioned within the Sky application, for example. I would just like to reiterate the following, to remind you of the following. A number of cases that are dealt with the Agency for the Prevention of Corruption and that will be subject to the limit of statute of limitations have to do with the prosecutors. And we return back through their careers and we analyze their assets, whether all the assets cards are something that everyone forgot about in the meantime, whether they were declared, and a large number of cases that are the focus of the work of the Agency for the Prevention of Corruption are not dealt with in an efficient manner because the assets were sold within the year and this has never been declared. And you all know that apart from this being the breach of the law, when it comes to the law on the prevention of corruption, this is also a breach that should be in the focus of attention of the Judicial Council and the Prosecutorial Council. The statute of limitation will result in a large number of cases being finalized, as in the matter of Medenica. The Judicial Council said that there is no legal grounds to continue with the process itself because of the statute of limitations. I would like to also draw your attention to another case which will fall victim of this provision, and this is the case of the new president of the Supreme Court, that Valentina Pavlitic, who concealed a company that this involves a vessel that was sold to the Pemex company, and this did constitute a serious violation in terms of the discipline procedure that should have been initiated. And because of the statute of limitation, it will not be processed. And that very case, as we were able to see, In the similar cases as the ones involving Ms. Mladenica, Katnić, and so on, the head of the prosecutor's office that are in pre-trial detention, everything that was happening in the past 20 years calls for vetting and shows that vetting was necessary. Ms. Laketić went through the due diligence procedure on behalf of the Judicial Council, but no one referred to the fact that the anti-corruption law has been breached, which shows that in the upcoming period, this will be a requirement if we want to have judiciary cleaned from the people with having to do with controversial companies, criminal clans, and organizations. And there is fear that everything that is yielded as a result from the prosecutorial office can be ruined in the future. Thank you very much. This is a great introduction for another question for Mr. Radonjić. What do you think of vetting? It could have certain situations have been prevented if we had it. And if it's introduced, do we need to introduce it partially, step by step, or automatically to have a comprehensive vetting institute? We are not against vetting, and this does not depend on our goodwill regarding this matter. Everyone who is employed and all of us that yield results that are recognized by international partners and the population here in Montenegro shows that we are not against vetting. But before we initiate such a procedure that is a complex one, requiring amendments to the constitution, establishment of certain bodies in charge of these procedures, then the participants in this procedure should be given right and some legal instruments remedies to act against the decisions of this body. The European Court of Human Rights in numerous cases against Moldova, Poland, Albania dealt with the justification of vetting, legality of the procedure, and these decisions haven't been unanimously approved. And we gladly use this word without actually understanding the procedure itself in substance. If we compare the situation with the neighboring countries, closest one being Albania, in which this procedure officially was initiated and introduced as of 2016 when certain amendments to the constitution were introduced, and then again in 2018, and according to the information that I have, it still hasn't been finalized. This additionally creates a burden for the work of the judiciary, because this impacts the procedures before the courts in terms of the length of procedures. This calls for the reorganization of the judiciary and for certain holders of the judiciary functions against whom the decision was made regarding determination of function. This impacts in the lack of staff, but can it bring some benefits? But I'm trying to say that this is a very complex procedure that cannot be introduced ad hoc. We cannot initiate it quickly and get some short-term results. But the Special Prosecutor's Office is not against it. But until we introduce the procedure, and I know that the attitude of the Ministry of Justice was that it shouldn't be focused on all the holders of the judiciary functions, but mostly higher-ranking judges, prosecutors, president of the Supreme Court, a Supreme State Prosecutor, presidents of courts, and so on. So they should be in the focus of the vetting process initially, and then later on, if necessary, to apply to others. But until this procedure begins yielding the result, we have some other mechanisms, ethical, disciplinary, and other types of liabilities that need to be strengthened so as to yield certain results within the procedure itself. The Special Prosecutor's Office to the criminal procedure showed that this is possible. When it comes to the authorities in charge of the disciplinary procedure against judges and prosecutors, is also to do what they need to do, but we also have some internal mechanisms of control, and the control that is performed by the Supreme Prosecutorial Office. There are some other controls when it comes to assessment of work and appraisals of judges and prosecutors, and at a certain point in time, we had the result that everyone was excellent in terms of the performance, and we know that this is not possible. And this is not validated in certain procedures to a sufficient extent. It's very important to work on the mechanisms and strengthening and enhancing the integrity of the holders of judiciary positions through providing adequate working conditions in terms of space, working space, basic equipment, wages, and also integrity needs to be in the focus of attention. Their expertise, which also needs to be reassessed in the same way that the assets, contacts, and other important elements are assessed. Because these are the key elements that have an impact on the integrity of the judiciary as a whole. So we're not against vetting, we're not against organizing special court, dedicated court. We believe there are some good aspects and points that could contribute to the efficiency of the criminal procedure before the court, but I'm just trying to say that this is a complex procedure, and we need to approach it from multiple aspects. And it's the way I see it from the points of view expressed by some officials, that this is not just a narrative before the electoral campaign. If we do not have an organic approach, a systemic approach, with the goal that after a certain period, which needs to be a lengthy period, to obtain certain results to the benefit of society. Mr. Radonjić, I've noted a certain type of reaction while we were discussing this question, so I would like to hear what you think about that thing. So this is not my area of interest, and I think that it is efficient and good, and through international context, this is something I would like to share with you. From some countries, I'm not really sure about the results of the process itself, but it did have some good effects. The ones that were the potential subjects of the vetting procedure, entities of the procedure. These were some results from some of the countries, and this is at least based on what I was able to hear. Well, since you mentioned international cooperation, I wanted to ask you the following. What is the situation like when it comes to Montenegro? And do we have good or a well-developed network? Having in mind that the tentacles of organized crimes are found worldwide, and there is this international component that is always present when talking about these matters. From my perspective, our international cooperation is one of the rare good points, positive points in our system. We wouldn't have made any progress if it weren't for the international cooperation. And the progress that was made is typically from international partners and other services. Unfortunately, we're very limited and restricted on our own. Of course, each country needs international support, but this is so clear in our case. So it is good. Of course, there are different levels of international cooperation that we can talk about depending on who you have as your counterpart. Certain countries do not provide for the information, but there are some other mechanisms that we can use to obtain data. Based on my work experience, I would really love to have a different scenario in the case of Switzerland, some island countries. And there are some, of course, variations in this regard, but I believe that generally speaking, we need to use all the benefits of the internet and potentials of the international cooperation. It's Tomović you wanted to add, just briefly to build on what was mentioned regarding the vetting. The working group, when it comes to the amendments to the law on the prevention of corruption, we talked about the Institute of Pre-Vetting and Vetting, or the obligation of the candidate. When talking about prosecutors and judges, that prior to the appointment and selection made by the consul to submit report and the assets card to the agency, and then this report that is later submitted to the Judicial and Prosecutorial Council could be used as a pre-vetting mechanism or tool. Of course, if this is governed and regulated under the law, this could also refer to the highest representatives and holders of judiciary and legislative powers. The Ministry of Justice, of course, needs to make the decision regarding this matter. I believe that a more realistic option is to work on a dedicated legal solution, organic solution that will govern this matter. My opinion is as someone who comes from the Bar Association and is in contact with the Prosecutorial Office on a daily basis, is that this institute needs to be approached carefully if we deem it necessary, and my personal opinion is that it is necessary to be introduced. It needs to be well planned, introduced in phases, and not ad hoc. All the normative conditions need to be prescribed clearly. The fact itself that when we analyze experiences from various countries that had introduced this system of vetting shows that we need to be careful about the potential consequences of the system. If this system is implemented under the supervision of political parties, that political parties will clean from this or clear out from the system all the prosecutors and judges that are not at their liking, and we will have older or even newer prosecutors and judges that are at their liking. This is a potentially dangerous system. This is why the norms regarding pre-vetting and vetting need to be defined in a manner that there isn't an institution, in a specific case, Agency for the Prevention of Corruption cannot reach any kind of decision, but only submit report to the competent authority, to the Judicial and Prosecutorial Council, that will, while making the selection and appointment of the judges and prosecutors, will take into consideration the report. In the same manner, when we talk about the law that is applied in Croatia for security checks, we could also think about the security checks as well, the so-called, of potential candidates, current candidates, but not in them to reach a decision. So the agency should just send submit the reports to the council, respective council, and the final decision will rest upon these councils. Of course, the same goes with the authorities from the legislative and executive branch. So I believe this is a rather complex procedure, and the very idea of establishing such a system within the legal system of Montenegro will most probably mean something similar that we had in the region, meaning that 10 to 15% of professionals from various branches will leave on a voluntary basis their positions, and of course we need to take care of preserving the high quality staff within the institutions and to enable them to work within these institutions, and also to attract new staff in terms of judges and prosecutors and other, of course, authorities which are for which these processes are under their competence. And I would also like to mention the pre-vetting. The law on the prevention of corruption introduced an obligation for the candidates, for the members of the council need to go the integrity checks. And how is this performed currently under the law? The lower authority performs this control of you as a potential candidate, makes the assessment, and if they get a negative opinion, and we had a case of a report that could not be interpreted legally as a negative. It was submitted by the agency. A colleague of mine and I submitted it to the competent state committee, parliament committee. That we didn't have any breach of the integrity, but the director used the situation in order to contaminate the selection procedure, which luckily was not successful because it was quite obvious the intention. But this is a real-world example that shows how this institute could be misused to stop the procedure and block the procedure of potential judges and prosecutors in respective bodies. So we have to be very careful having this in mind, and we need to be very careful when introducing these normative solutions. And at the very end, I would like to point out something regarding the problems that we were able to hear from various institutions. The worst laws, pieces of legislation can be applied in the best possible way. In the same manner, the best legal solutions can be the dead letter on the paper, meaning they are not implemented and enforced, which means that all the institutions should consider the following question: the manner in which the new legal solutions, pieces of legislation, will be applicable in the current ongoing cases and cases from the previous period. It is true that Article 147 of the Constitution prescribes that retrospective application of the law is prohibited, but the same article under paragraph 2 stipulates that they can be applied retroactively if there is a public interest for that. And of course, this is an area where in organic laws, the criminal code, and the law on tax administration, law on the prevention of corruption, to introduce provisions that will be elaborated from the aspect of public interest with retroactive application. Only such solutions can improve the fight against corruption. Everything else is just a political narrative that will not contribute any strengthen the authorities to yield specific results. And thank you very much. And sorry for taking much of your time.
Is there any question from the audience? Let me ask Mr. Laketić. This is a hypothetical question, and I hope you understand. If you had a magic stick and you could use it only once for your directorate for the sake of confiscation, how do you think we should start? Where we should start? And what should be prioritized in order to have good tax directorate that would scare the criminals, chill off criminal intents? And the question for Mr. Radonjić, you said we should apply the law as it is, and it's not only, yes, it should be applied to confiscate proceeds. And where is the problem? Why? Is it because of your FIU, because you are not prosecuting that, or it is the reporting entities problem? The problem is on reporting entities who do not report, or the problem is with or lies with the prosecutor's office, which does not prosecute the cases. And the problem is not with the courts and judges, because we had so few cases that we can't conclude that they are the problem only. Montenegro was notorious as a destination where money was laundered, legitimate, dirty money was legitimate, was coming from all sorts of places. Russian, German, Chinese, Turkish, Albanian, whatever. It hails from all over the world. Hundreds and hundreds members of criminal organizations on top of our 11 criminal groups use this destination to do the money laundering, and we never managed to get them. And then you say that we should apply this law and how we should do it in order to get to it, and why we haven't done that before. Who goes first? So yeah, I didn't say it's only that problem. My claim was that we can't copy paste. If we want to take a Slovenian model, we should do the model, and we can't exactly replicate it. We are not using the present solution. How can we change something that we don't apply? If we confiscated properties, assets, and proceeds last year, we wouldn't have this issue. It is the efficiency of at least 4 institutions in the chain of command or work. So I can't put finger to any of these, but I want to say that the chain of cooperation is not working well, and that is what I pinpointed, and only then we could have a magic stick. If I can arrest this question, you know what I would do? I would stop chasing the goods. I would chase the money. If we apply the principle, follow the money, you won't have any problems because nothing could affect it. There is no statutory limitations to that. You talk about the assets as the instrument of crime and as the proceeds of crime. If we manage to do those cases and prosecute them, it is only then that we will have visible results. There is one country, and I won't name that country out of correctness. There is one country of the region that managed to apply and prosecute money laundering. In three forms, and one of them was prosecution of perpetrators as a standalone money laundering. It is a flexible evidentiary standard. You don't have to prove that its origins are from crime, and you just prove that it's from criminal activity, some criminal activity, and then the burden of proof is on that person, and that person needs to prove that. And this country, out of 280 money laundering cases, has 46 standalone confiscations, 380 million confiscated, and euros confiscated, and this is what we need to have if we have magic stick. But it doesn't go smoothly with prosecutor's office. Prosecutors have to look upon the courts what to do. We don't have any single decision or ruling on standalone confiscation, and we should talk publicly about this. So no one is to blame. I can't blame and put fingers on I'm one in the chain. I can be that, but you don't need to push me to blame for inefficiency anyone in that chain of cooperation. It's difficult to imagine that I have it, a magic stick. I think this should have happened some couple of decades before. However, it is important to have one case, no matter if that is high official or not. And even if we make a mistake and we learn something, the focus would be sooner rather than later, because every day lost gets problems accumulated, despite the fact that we see the things differently and we had a different manner of presenting our personal views. I think the lack of track record and so on, we have a high level of harmony and the same level of frustration for not having better results, and the solution is in our hands, exactly as Mr. Radonjić said. We have to apply what we have and to build up what we are missing right now. We are far from ideal models, and we shouldn't wait for ideal and idealistic, but to do what with and act with what we have in our hands. So no magic stick. Any more questions? No? So let me use this opportunity to thank all of you for very constructive discussion. I hope I believe that it was all very interesting. For some things we need the magic stick, for some it would be useless. But we should, without magic stick, schedule the next convenient conference, for the next year.